Okay, the November 7th Metro Stormwater Management Commission to order. My name is Kabir Sandhu. I'm serving as chair of this board, and I think today we have a relatively short agenda, but we want to go ahead and kick this thing off to provide ample time for that case. And so with that, it's customary for us to, for our first order of business, is to review the meeting minutes and decision letters. And we do that in the public forum, and I'll give the commissioners a couple minutes to review that, and I'll entertain a motion for both combined when ready.
I need to abstain because I missed that meeting, but I have reviewed the video.
Great, so Mr. Campbell abstain. Okay, we have a motion from Commissioner Lewis to approve. Is there any discussion, or is there a second? Second. It's been seconded. Any other discussion? All right, seeing none, all in favor? Aye. Any opposed? None, and I know we have one abstained. Okay, second item on the agenda is deferrals. Just for the record, case number 2024-00024, 3702B Estes Road will be deferring to December 5th. Is there anybody here in the audience that is here for that case? Great. That means our notices are working as they should. Anything to note on that case, Logan?
The owner is trying to revise his plans, possibly to not even need a variance, but I haven't heard from him in a little bit, so I'll follow up after this meeting, and we'll see where we are. Great.
All right, next case on the agenda is the Ariza Bellevue case. If the applicant could come to the front here, and while you're doing that, I'll let Logan introduce the case.
Opening statements of the applicant. If you are not satisfied with the decision made by the Stormwater Management Commission, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the Commission's decision. You are advised to seek the independent advice of legal counsel to ensure that your appeal is filed in a timely manner and that all procedural requirements have been satisfied. Case number 1 on the agenda is case 2024-00022, Ariza Bellevue, 1084 Morton Mill Road, and 7880 Coley Davis Road. APNs are 1411120E04500C0, 14100001700, and 14100007400. Inspector is NPDES, Council District 35, Jason Spain. Applicant's request, disturbance of the floodway and buffer to construct a 12-foot impervious greenway path in Mow Strip for the maintenance as required. Disturbance of the floodway and buffer to construct a vehicular bridge at an angle greater than 15 degrees and within 1,000 feet of a pedestrian crossing. Appellant is Daniel Moda, Cypress Brook Company, represented by Andrew Tarsi, Reagan Smith. Comments, Stormwater staff. Proposed mitigation consists of allowing the Zone 2 floodway buffer to naturalize/remain undisturbed and planting trees in the buffer. The Zone 2 buffer conversion may be impacted by potential sports fields. The latest mitigation plan utilizes larger diameter trees versus bare root seedlings, which satisfies our original staff comments re seedling survivability. Project will attain a letter of map change through FEMA. Codes, no comment provided. Planning, the Greenway plan proposed for this case appears consistent with the approved preliminary SP. Greenways, Metro Parks, Greenways and Open Space Division staff recommends approval with conditions of the stormwater variances related to the Greenway improvements and access improvements being provided with this project. Greenway staff has been engaged with this applicant since 2021 and has provided feedback regarding the applicant's plans to include an extension of the Harpeth River Greenway across this property to connect with the Morton Mill Greenway segment and the Harpeth River Park Greenway segment. This is a significant piece of the planned Harpeth River Greenway and is consistent with the department's original waterway-based greenway system plans established in the early 1990s and reflected in all master plan updates since that time, including the 2016 plan to play. The subject project is extending the Harpeth River Greenway under a CSX railway and through the subject site, connecting the current terminus of the Greenway to the existing trail and pedestrian bridge associated with Harpeth River Park and soccer fields. The project also is providing multimodal access to the adjacent unimproved 51 acres of parkland that was donated to Metro Parks in 2019. The proposed Greenway extension would connect the existing 6.4 miles of Harpeth River Greenway originating in Edwin Warner Park with Coley Davis Road. Future right-of-way improvements from Harpeth River Park to Highway 70 and the Bellevue Mixed Use Center would enable multimodal access from the Warner Park system, the Harpeth River Greenway, and the approximately 5,000 residents with low-stress access to the Harpeth River Greenway, to Harpeth River Park, to Coley Davis Canoe Launch, to Wego Park, and Ride and Planned Transit Center location on Coley Davis Road, to the Bellevue Mixed Use Center, and to the Bellevue Regional Community Center and Ford Ice Center. Additionally, the application proposes to build a greenway connector paralleling the railway on site to enable a future greenway loop with a future improvement of the 51 acres of Metro Parkland adjacent to the site. Additionally, the applicant is proposing to dedicate approximately 20 acres of land outside the developed area and largely within the floodplain to Metro Parks. This land dedication would enable potential expansion of the Harpeth River Park and conserve open space around the Harpeth River Greenway. Additionally, the project is providing vehicle access via the proposed bridge from Coley Davis Road to the 51 acres of unimproved Metro Parks land that is currently inaccessible by vehicle. This vehicle would enable future park build-out of this Metro Parks land. Greenways recommends approval with conditions of the stormwater variances related to the Greenway improvements and access improvements as they are consistent with the department's master plan, represent a significant improvement to this Greenway corridor, and enable greater multimodal access to public open space. Conditions of approval: the final planting plan for the mitigation area shall be provided by Metro Parks Greenways Division and shall ensure proper sightlines are provided for the Greenway, among other considerations such as those related to programming and maintenance. The owner of parcel 141-0000-1700 shall be responsible for tree maintenance and replacement within the mitigation area for 2 years after planting. If at that time Metro has accepted the proposed park greenway dedication, the owner's responsibility will cease. Otherwise, the owner will continue to maintain and replace the trees until the park greenway dedication is accepted by Metro.
Great. That was a thorough analysis by Parks and Greenways. Thank you for that. And note that there are conditions that are stated in that analysis that should be possibly incorporated in our ruling today. So I want the commissioners to recall that. Okay, I'll give a recap of how this goes. I know that the applicant's been here before, but just I wanted to let the audience know that the applicant did request additional time for their presentation, so I've granted that given we have a lighter caseload, and there's been a lot of attention to this case. So they've reduced their variance request to 2 from the 3 from previous, and I've granted 10 minutes for each of those 2 components, so a total of 20 for the presentation. I'll give you a 2-minute warning. We'll close the presentation, open it up for public comment, and anybody here to speak in favor or against should come to the podium and press the button to be recorded. I was also contacted by the Harpeth Crest subdivision HOA president and have granted additional time to them. They'll have 10 minutes to consolidate the comments from the community into one presenter. And if anyone else is here, they're welcome, of course, to come up. After that, we'll close public hearing, and we will open it up to the commission for discussion, and may have some back and forth with the applicant. So with that, I'll go. Is there anything else we need to mention?
It has been brought to our attention as the commission that before we hear the case, we also need to determine whether or not the variance is something that we can rule on, as to whether or not this is a developed property or not, based on Metro Code and the provisions in our regulations.
Yeah, I think what you do for that purpose, so there's a question of whether 1748 is applicable. I think let's hear out the applicant, let's hear out the rebuttal as to whether they think it's applicable, and then you guys will start your deliberations. But thank you for putting that to the forefront of everyone's mind.
Okay, thank you.
All right. With that, I'll let you all introduce yourself and start the clock after that.
Mr. Chairman, members of the commission, my name's Sean Henry, 500 11th Avenue North. Just want to introduce the team here real quick. Laura Jones with Reagan Smith is going to be the primary presenter. We have Brian Ralston from Banesh, a civil engineer, and Dan Moda with Cypress Brook. I want to also mention that Mike Novelli, who's founder and CEO and president of Cypress Brook, is here as well. And we would like to reserve as many minutes as you would give us for rebuttal. So thank you, sir.
Great.
Thank you so much.
If you would mind pressing the, yep, thanks.
Thank you so much, and good morning. Laura Jones, environmental engineer representing Cypress Brook Company. As you know, we are here for the Ariza Bellevue development, and per our application, our presentation here will show good and sufficient cause, exceptional hardship, and proof that the proposed project will not increase flood heights. As previously mentioned, we are here to discuss 2 variances.
And would you mind pulling the mic down to your, yep, so we can, yep, perfect.
Yes. Is that a little better?
Yes.
I apologize, I'm a little hoarse. So the 2 variances that we are requesting are shown here on your screen. 1 is for the Harpeth River Greenway Trail, and 2 is for the public multimodal bridge. It should be noted that the multifamily development portion of the site does not require a variance, as it is in full compliance with the stormwater regulations utilizing LID development practices. Also, we have adjusted 650 feet of the Coley-Davis roadway improvements to elevate Coley-Davis and avoid additional impact to the Zone 2 buffer since our last presentation. Therefore, that variance is no longer needed. We are also no longer requesting a variance for buffer signage, as we will install the standard buffer signage and the educational signage along the trail as well. As you can see here in this slide, this project has a very unique site setting. It is located in an artificial bend on the Harpeth River, which I will elaborate on in further slides. It has potential connectivity, as mentioned previously by staff in their comments, to the Greenway Trails, the WeGo Park and Ride, and connects the community in a very critical component. The site is adjacent to a parcel owned by Metro Parks and is currently landlocked by the Harpeth River and CSX Railroad. The site cannot be developed without vehicular access. This slide shows the unique site characteristics of the Harpeth River bend here. The Harpeth River was actually rerouted with the build out of I-40, creating a very unique and artificial bend in the river. This provides some unique site constraints with regard to a bridge over the Harpeth River and the angle of skew crossing that bend. As you can see, it's a very sharp, unnatural bend in the river. Here is a slide detailing the connectivity. As you have heard in previous comments from Parks and Greenways, I'm not going to elaborate that too much, but it is a critical component to a multimodal system. And this particular section of the proposed Greenway Trail connection is shown in the dotted red line that you can see there. The green line is the existing system, and the purple is direct access to I-40 and park and ride facility. So this is definitely a missing puzzle piece that we hope to incorporate. Okay, so this slide is a summary of the hydraulic modeling that was done here to provide the no-rise information. Previously, Commissioner Camp requested a summary of this information, which we have now provided, and hopefully this is very informative. I want to discuss for a minute that previously when we were here, the model showed no rise between the effective model and the proposed model. However, there was a very slight incremental rise between the existing model and the proposed model, which was cause for some concern. We have since redesigned the bridge and the safety canopy in order to ensure that there is absolutely no rise whatsoever between both the effective and the proposed and the existing and the proposed model. So across all models, we are showing no rise. In fact, in some cases, it does go down, and you can see that. So how did we accomplish this? Well, we changed this bridge from a 5-span bridge to a 3-span bridge. We also changed from concrete to steel girders, which allowed us to raise that lower chord up. And we did shift the abutments so that they are now aligned with the flow of the river in order to reduce any impacts on the flood areas. It's a slight delay here. There we go. Okay. As you can see, we've done thorough environmental analysis, regulatory constraints, environmental report, ESA coordination, phase 1 archaeological, and most recently, Davey did complete a nest survey to verify that the nests discovered at the soccer fields were osprey nests. A little more on the background. This shows the preliminary SP plan approved by the Metro Planning Commission and Metro Council in 2023. Just to recap here, the preliminary SP included the following public benefits: raising Coley-Davis to the 500-year flood level elevation. This is due to the fact that there has been a history of some flooding concerns on Coley-Davis and limited access for residents to safely get in and out during a flooding situation, as well as emergency vehicles getting to them. This is a public improvement that will significantly improve safety in the area for the general public. It also includes constructing a public multimodal bridge from Coley-Davis to the multifamily and the Metro Parkland, as mentioned by staff comments earlier, extending the trail access across the CSX trestle and connecting the existing trail at the pedestrian bridge, as well as along the southern edge of the site towards Metro Parks land adjacent to the property, and donating at least 20 acres of floodplain to Metro Parks. And we currently estimate that that dedication of that parcel will actually be a slightly more than the 20 acres originally agreed upon. And this next slide, there we go. This is a summary of the community engagement that has happened on this project over the course of 2 years and 6 public meetings hosted by council members and Metro Planning. There has been many opportunities for public engagement throughout this project. This just highlights that. I'm not going to go through that whole list. But on the next slide, you can see that not only was there public engagement, but the comments from the public were taken into consideration and formalized in this plan. So these amendments were created based on the public comments that were received in those public hearing and public meetings. a little background on the CSX trestle. As we mentioned, that this is a landlocked property and it can only be developed with vehicular access. CSX has definitively declared that they will not allow vehicular access beyond the existing driveway, which will only be allowed to be used for emergency vehicles. They have been working over 3 years to negotiate the right to use that existing crossing for emergency vehicle access. However, since CSX will not allow any other vehicular traffic across their existing trestle, the only way to access this property and the Metro Parks property is by building a bridge over the Harpeth River. Also mentioned in this is the trestle safety canopy that we will discuss in detail. The next two slides just show an overall site layout plan. Highlighted in green at the bottom is the greenway, and highlighted in orange at the top is the multimodal bridge. And this just shows the grading and drainage as well. We can always come back to those if we have more questions. Here we go. Okay, regarding preserved floodplain, this slide is just to demonstrate that we are currently preserving 50%, actually more than 50% of the floodplain. This shows a worst case possible scenario if parks were to build out future soccer fields, which is not part of the variance at this time. However, we do know that Parks does have an interest in building out soccer fields here, so we wanted to show that, incorporate that into the plan as well. Even with that future build out, it still shows a floodplain preservation of at least 50%. Since the project is preserving a minimum of 50% of the natural floodplain area per section 5.4 of the Stormwater Management Manual, it does not require a variance for encroachment. Therefore, that Section 17.28.040A of Metro Code does not apply. So I just wanted to clarify that. Okay, moving ahead. So this is just a recap of the variance that we are requesting for the Greenway Trail. The trail will be 12 foot, narrowing to 10 foot 6 inches through the safety canopy underneath the CSX trestle, and then widening back. Thank you. And then widening back to 12 feet. We are requesting a maintenance mow strip of 5 feet on either side of the trail outside of the safety canopy's extents. And there will be an impervious area of the park's dedication parcel. The mitigation elements for this variance request are that the safety canopy and trail designed to achieve no rise in flood heights, which we discussed. There's no uncompensated fill in the floodway or floodplain. There is a overall net cut. We will be maintaining Zone 2 floodway buffer area of 1.22 acres as a no-mow zone, removing invasive species, installation of riparian planting mix, which we'll discuss in more detail, and planting 142-inch caliper trees. This is a slide that demonstrates some of the other agency coordination that has occurred and is ongoing. And the next 3 slides will show you the coordination that we've had with Greenway Master Plan. I'm not going to go through this in detail since that was discussed in the previous staff comments. But again, as you can see, this site is critical in that existing Greenway priority plan and has been for many years now. So this is definitely a much needed community improvement. Again, this is another example of the Harpeth River Greenway Trail there. You can see enlarged in green. These are the details of the safety canopy that we can come back to if we have any specific questions, but I'm going to click through these fairly quickly. Just a couple of things to note here. The safety canopy is designed to both be resilient to floodwater, inundation, and debris, as well as it has the ability to be removed in 3 segments per requirements of CSX if there's ever any maintenance that needs to be done. Oh, here we go. Okay. Commissioner Oliver requested more detail regarding the outfall on the HOA pond regarding the impacts to that. So this slide is to explain that in a little more detail, you can see there in the overall and then the detailed view here that the drawing shows that the proposed culvert under the trail is outside of the HOA pond outfall. The culvert is capable of handling more than 500% of the flow of the HOA pond outfall. In the event of overtopping, you can see that the trail is located below the culvert, and so the trail would simply overtop and not cause any ponding or backup behind it. So in summary, the proposed connection avoids any impact on the HOA's existing facilities. The next slide shows some graphics of the proposed Greenway Trail, 12-foot wide with a 5-foot mow strip. And then this slide shows some alternatives that were considered. So the 5-foot natural surface trail, which is not compliant with ADA requirements and therefore was not a feasible alternative. We have the 12-foot wide proposed trail shown here and the 10.5-foot wide 10.5-foot wide trail that's proposed in limited areas. 14-foot is the park's new standard. However, we have worked with parks in order to come up with an agreement to do a 12-foot wide trail. So going to the alternative designs here, we have two alternative designs of the location of the trail. Alternate design 1, as you can see, does not allow for full use of the dedicated facility by parks. You would have a maximum of 2 soccer fields. And alternate 2 shows the same number of soccer fields as the preferred alternate. However, this has a more significant environmental impact as it does have more impact in the floodplain and decreases the amount of floodplain preserved. Therefore, those 2 alternates were not the preferred alternate. This is a conceptual rendering of the safety canopy. And moving on to our next variance request of the public multimodal bridge. This request is to construct a public multimodal bridge at an angle greater than 15 degrees. The estimated angle currently is 28 degrees. And to locate the bridge within 785 feet from an existing Metro Parks pedestrian crossing. The mitigation elements proposed here is a no rise in flood heights, no uncompensated fill in the floodway or floodplain with a net cut, maintain zone 2 buffer area of 1.22 acres, removal of invasive species and planting of 142-inch caliber trees. This is the agency coordination that is ongoing and current. And this is a detail of that public multimodal bridge. So as you can see, we are at the furthest most point of the property that we can build the bridge. We're not able to go any further because we don't own that property. So the 785 feet distance is the maximum that we can achieve from the existing pedestrian crossing. The skew angle, to discuss that in more detail, we did look at some alternatives. However, whenever we tried to get it closer to the 15 degree skew, it did cause a rise in flood heights. So the 28 degree skew is the design that is preferable because it has the least impact.
I'll just note that you have 4 minutes.
Thank you. So the next few slides are details of that bridge that we can come back to if we have further questions. Click through those. This is another, so this shows the bridge skew layout and how that skew is calculated. There was some question about that previously, so we have those details. This also shows the scour and velocity analysis that we provided. There was some question from Commissioner Fulmer about the scour analysis. I just want it to be noted that all the shear stresses are below 1 pound per square foot. And so there's no concern about any bank scour. We did look at alternatives, as I mentioned, of the skew, and as you can see, those alternatives have a greater impact on the floodplain and therefore did show an increased rise. And so they were not the preferred alternative. And then quickly moving through here to the mitigation plan. That's not showing up very well here. Try this one. All right, through this section, you can see the trail and the floodway buffer highlighting the preserve space that will be provided by Metro Parks. The overall mitigation plan proposes 7 acres of mitigation against an impact of 2.68 acres. So we have more than 3 times an area of mitigation versus the impact. As you can see, the plan consists of maintaining 1.22 acres in a zone 2 as a no-mow zone and planting 4.34 acres of riparian seed mix areas. Those areas are shown in blue. We also have another detail here that shows possible mitigation if the sports field were developed in the future.
You have
And
2
this
minutes.
is to show what the build out would look like. These slides are not showing up here. Another mitigation that we have here is the stream buffer signs. As we said, we'll be using the standard signs as well as the interpretive signage. In closing, thank you for considering this variance. We will leave our time for rebuttal.
Great, thank you for a well-timed, thorough presentation and also addressing a lot of our concerns from our last meeting. So we'll certainly dive back into that upon discussion. So with that, I'll close the applicant's presentation. If there's nothing else, I'll confirm that. Is there anything else that the applicant would like to discuss? Okay, great. And with that, I'll open up public hearing. Is there anyone to speak? If you are here to speak in favor or against, would you please raise your hand? Okay, so we have a few. So let's start with those who are in favor. Is there anybody here in favor? Raise your hand. Great. If you wouldn't mind, come on up to the podium and introduce yourself with your address and name.
Thank you. Former council member Charlie Tigert from the Bellevue area, 617 Poplar Creek Trace Court, 37221.
Mr. Tigert, sorry, I forgot to tell you that you have 2 minutes. So, thank you.
Well, I think my training on the council taught me that lesson because the microphone gets turned off. So. I need to tell you, I have a vested interest in this. As the original sponsor for Greenways in Nashville, who went through a lot of trial and error and pain and suffering to get us to where we are in Greenways, I felt like this is the final step in the Harpeth River Greenway, the Morton Mill Road Greenway, which I supported and passed in council as the pilot project for all greenways in Nashville. This stretch of greenway has been open for 30 years and uncompleted for 30 years. We knew it was coming because Metro Parks, at 1 year in the budget process, formalized the money to pay for the pedestrian bridge. So this has been an unfilled need for many, many years. The 12-foot wide variance requested, it'd be like building a 1-lane interstate now, based on the traffic and the popularity and the usage of the greenway system in Bellevue and the Harpeth River. It would make no sense to go anything less than 12 feet. So I just, I'm here to support and say that the overwhelming majority of the community that use this greenway, and there's hundreds, if not thousands every day, would appreciate your support of this. Thank you.
Thank you, Mr. Tigert. All right, is there anybody else to speak in favor? Okay, for those who are here to speak in opposition of, would you please, next person come to the mic and introduce yourself with address, and I'll give you 2 minutes.
Good morning. My name is Ann Gwynn. I live at 1060 Todd Priest Drive, which is in River Plantation. I come to speak in opposition. I think this train is way out of the gates already from the way it sounds this morning. But I've been here before when the walls were down and this whole room was full, and we were trying to tell you, not as officials, not as technical people, but as residents, that we want our properties protected. I'm not concerned that these people are gonna get flooded. They'll be way above the river, okay? I know that. They'll be safe. Those of us at the bottom will not. I had 6 feet of water in my house, and I'm at the bottom of the hill just across the river. And I know you all have all these technical experts, and you all know the water has to go somewhere. And maybe those conditions will never exist again, but we didn't think they ever would in the first place. So I just ask you again, I don't know how many times it takes for us to come and bring these concerns to you, that we're concerned about our property and our lives. People lost their lives the last time this happened, and you all may not, I don't recognize a lot of your faces, some of you look familiar, but you may not even know what I'm talking about. We had a flood in Bellevue, and it was catastrophic. And we need to be considering. I understand about the Greenway. I appreciate that, Charlie, and the work that you've done on it. I really do. But I think we have to weigh. Are we more interested in recreation or in people's ability to live their lives in their homes? So that's what I have to say. I ask you please to consider all of these factors in addition to where you put the greenways.
Thank you, Ms. Gwen. Next person.
Good morning, Steve Socia, 7740 Riverbend Way. 3 quick points. On September 5th, a contributor to these proceedings cited Tennessee case law that requires the developer to have a hardship in order to obtain any variance. Not some theoretical hardship on the public. Yet, counsel for Cypress Brook stated twice in that meeting that there is no hardship on the developer that would justify a variance. And for the record, there is no current hardship on the public, as easy access to the Frisk Park has been available for decades by simply walking or riding across the footbridge from the soccer park to the existing greenway that's been there for years. Number 2, the plan that Cypress Brook used to obtain the zoning change, original zoning change, included raising and widening Colley-Davis Road. And as they stated, that approach would in fact raise the downstream level of floodwater. Sounds like from what I heard this morning, that may be changed. I don't know how you vet that in the next 45 minutes. But you all then pointed out there should be zero rise. Furthermore, their plan included widening Colley-Davis Road southeast toward the development property. Now, from what I hear, that part of the development plan appears to have been removed. So how can you approve and further a plan that violates that which was submitted to Metro Council? Would that not call into question the zoning approval overall? Third, in that September 5th meeting, I submitted photographic evidence that next to the development site where I live, we've had significant floodwaters in the 100-year floodplain twice in 11 years. So let's not pretend that weather patterns aren't getting worse. They are. We've all seen what can happen with excess rainfall with more than 100 people dead in North Carolina. We don't want this project to be the next disaster. Even if the developer's plan in front of you met all the legal requirements for approval, which it does not, it would still be a very bad idea for the many families living in this area, and especially for the possible 1,000 people who could end up living in this development. So I strongly suggest you call a vote today and deny any and all requested variances for this property. Thank you very much.
Thank you, Mr. Socia. Next, please.
I've tried to keep my comments to 2 minutes, but
It's okay.
before I start, could I just correct 2 factual issues that I think have come up in the application, or could I ask for an extra minute?
I'll give you an extra minute, certainly, if you would mind introducing yourself and address.
Sure. Jim Rossi, 7704 Scenic River Lane. Let me just start out with what I think are 2 factual misstatements from the presentation. First, it was said by the applicant that the site cannot be developed without a vehicular bridge. That is false. To the extent, first of all, CSX can't require a bridge. Second, to the extent CSX is requiring a bridge, that's because the applicants forfeited access in its negotiations with CSX. And if you look at the December 2023 planning policy for this parcel, it states the site can be developed with an at-grade crossing at the CSX tracks. The SP itself says that the zoning reverts to RM9 if the project with the SP conditions is not built. So there are other development options here. Second, a slide states that the construction permit is pending with TDEC. As of yesterday, that was not true. TDEC sent that application back to the applicant in September because, among other things, it was incomplete. One of the problems was the applicant did not acknowledge that this segment is a Class 3 protected river under the Scenic Rivers Act. That makes it an ETW, an exceptional Tennessee water. The TDEC protects, and that'll affect the protected buffer as well as sedimentation control during construction. Let me move on to the issue I want to talk about, and that's the issue of preserved floodplain. According to 172840 of Metro Code, and this is subsection A of the current version of the code, in the preserved floodplain, variances shall be approved only if this commission finds that the encroachment reduces the flood danger, it would improve and enhance the quality of the affected floodplain section. So on top of any determination that you all need to make regarding ordinary variances that you grant in many instances, exceptional hardship, good cause, increase in flood heights, et cetera, for preserved floodplain, the commission needs to make the findings required by 1728-40. Nothing in the application shows that the requested variances would reduce the flood danger or enhance the environmental quality of preserved floodplain as is required by this provision of the statute. Now, the terms preserved floodplain are not defined in the statute. The applicant's presentation appears to have relied on a pre-2016 version of the statute, as well as a Metro Water Department reg that defines preserved floodplain more narrowly based on this 50% standard. But the current version of the statute is directed to this commission only. And you need to decide what the current vision, which does not include the applicant's 50% standard, that was explicitly removed from the statute in 2016, what this provision means. Let me mention a few starting principles here that could apply to interpreting the terms preserved floodplain. A, nothing in the statute limits or modifies these terms. Elsewhere, council has used the terms natural floodplain, but it did not do so here. Second, Metro Code controls over any conflicting provision of the stormwater regs or the stormwater manual. And third, if there's a conflict or ambiguity in the department's regs, Metro Stormwater Department rules say this should be resolved to favor the most protective interpretation of the law. So what is preserved floodplain? As a matter of legal interpretation, if you apply these principles, this would include a natural floodplain, but isn't this just as natural as the coast of a dam reservoir, which would be natural after more than 60 years. It also includes anything in a conservation easement, preserved floodplain because of land use policy, and raw undeveloped land that over decades has come to serve the environmental and flood control function of natural floodplain through inaction if it hasn't been developed. Note that this chapter, 1728, am I getting it right? 1728, is titled Environmental and Operational Standards, right? It's focused on environmental protections, and those environmental protections extend beyond just natural features of the land. Am I out of time?
That was time, but I'll give you a couple seconds to give your closing.
I'm sorry, I could go on, and I won't. I think you all need to hear from others about this. I want to thank you for your time and patience. I was very impressed with your attention to detail at the last meeting. And I just want to say that time is always right to do what is right. And this commission, I think, has some authority and some tools. And I would submit a legal mandate to reject this variance. Thank you.
Thank you, Mr. Rossi. I'll note that we did receive your comments by email, and I've read all that, and that's been distributed amongst the commission. So thank you. All right. And I'll note that I gave Mr. Schultz an additional time to speak on behalf of the HOA, so you'll have 10 minutes, and I'll start your time after your introduction.
Thank you. That's good. My name is Devin Schultz. Can I do the same thing with correcting the record, except for last meeting? Do you mind if I?
Sure.
Okay. There's just one thing, and I mentioned this to Tara earlier today. There was a comment made, she made the comment that there was a conservation easement in favor of Metro Parks. And just for the record, because somebody asked if there was an easement in place. There is, the only document that relates to an easement, the only recorded document is the plat. So I don't want to litigate to the extent that it matters at all, but there is no conservation easement in favor of Metro Parks, the Metro Parks Department. There's nothing on the plat that references Parks Department, so that simply isn't the case. I asked her, I was like, I don't want to put you on the spot, but this is what I'm gonna. Is that a correct statement?
It's correct that there's no express written easement other than the dedication on the plat. And I consider the dedication on a plat an easement to parks.
But does it say anything to parks, just for clarity? There's no reference to Metro Parks, right? I'll
believe there
stipulate
is.
that it doesn't, if that's okay for the record. That's all I'm gonna,
Chairman, if I could not like infringe on his time?
Sure,
I
hit
think-
pause.
I think the recorded plat says dedicated conservation / greenway / public access / trail easement area.
right, just those 9 or whatever words. There's nothing else beyond that. So that, just for the record, that, I, again, didn't mean to litigate that entire thing, so.
Okay, thank you.
Again, Devin Schultz, 7348 River Bend Road, president of the HOA, again, not representing the HOA, and my attorney capacity just as the president of the HOA. Commissioner Camp last time made a specific request to hear more about plans for alternatives uses. She may have been doing so under F113, which talks about availability of alternative locations, not subject to erosion damage for the proposed use. I'm not sure if she was talking about the whole project, but I'd like to call your attention to the bottom right-hand corner where our property abuts the CSX tracks and that little loop there, that white loop. This is referred to as option, this is from the SP, by the way, the applicant's SP. This is option A, which is the Greenway underpass that they're sticking with now, and option B, which is the Greenway tunnel, that I don't think you've seen anything on. Both of these were presented as pre-approved by CSX options to Metro Council and Planning and Parks and the public. This is a quote from Alan Thompson. CSX has given us a preliminary approval on both routes, and it's a matter of which route that works, and Metro Parks will coordinate with CSX on the final route. So that's echoed in the Metro Planning Commission meeting staff notes. This actually says Parks is okay with it as well. So at this point, you have Council, Planning, Parks, the applicant themselves, and purportedly CSX themselves are all okay with both options. And then this came up just yesterday, and maybe it had been around for a while, but I only saw it yesterday, where it says CSX issues a decision selecting the under-bridge option to be pursued for application. Well, this is an admission by applicant that they have failed to meet virtually any of the standards with respect to that aspect of their application. Granting a variance based on CSX told us we could only cross their property if we also disturb the buffer on property of a third party who, regardless of whether or not there's an easement that allows it, as opposed to having their property messed with, would be a radical violation of the variance standards. If the Stormwater Management Commission grants a variance when Planning, Parks, Council, and the applicant themselves, and purportedly CSX, have all on the record acknowledged that alternative site plan is available and acceptable, but CSX has issued the decision that necessitates a variance on the property of a third party, even when that owner of the property opposes such a variance on their property, is setting up an extremely dangerous precedent and opening up a legal Pandora's box. The Commission would be allowing CSX as a third party with near zero risk to health and safety of the community to dictate to the Commission that variance is necessary, even when there are acceptable alternatives that would not require a buffer variance. Consider the precedent that was set for future variance requests. You have neighbors gaming the system. You could have all kinds of, it's just a mess. So how did we get here, right? We kind of went over this yesterday, or last meeting, but the reason we're here today is because the applicant pleaded with the Planning Commission and Metro Council to approve this project via SP legislation with a myriad of carrots to induce these bodies to conditionally approve the project. However, there was so much concern about the details of the project, the Planning Commission applied multiple supplemental policies to the project, and the Council added multiple amendments because they were concerned about the applicant making good on all the goodies that had been promised. All along the way, while the community screamed from its collective lungs, the council, planning, and et cetera were told the community was demanding too many details, and if the council just approved this next step, then the applicant would be free to spend all the extra money and flesh out the details.
SP, and that's what you all consider, is whether the project is feasible. Your professional staff, NDOT, all of the departments and agencies that have reviewed this find this project feasible. Of course, it's subject to final construction drawings that will come at a later date when the final site plan is submitted. The neighbors want that now. That's premature. Once this council decides whether zoning is appropriate, my client is free to spend a heck of a lot more money in drawing up those plans.
So now with more detailed plans in hand, we can see the myriad of issues that there are with this plan. Now the applicant is saying, we can't develop this property unless you grant the variance. It's a less than forthright approach. Step 1, claim the demand for details is premature in order to get approval from planning and council. Step 2, when it comes time for the details to be examined, claim that it's too late to do anything else. We can only develop the property this way, and it's a hardship if you tell us no. So this was advertised as the top benefit from the top carrot, from the number one benefit from the developer. Again, these are promises. This is the council member who pushed this through. He made it clear, this is a quote from him, that these are promises made by Cypress Brook, and if there are any roadblocks to prevent them, the project simply won't move forward. At the last meeting, we spent some more time addressing their statement of hardship, which seems to remain mostly or totally unchanged. In short, we said, how can something that the applicant dangled as a proverbial carrot in front of the Planning Commission and Metro Council to persuade them to change the community plan, rezone the property and allow such an intense use of the property suddenly become a hardship? In response, the council testified not once, but twice that they themselves did not have a hardship.
The language in your stormwater regulation says failure to grant the variance would result in exceptional hardship. The result of exceptional hardship here is on the public, not on the developer. Again, failure to grant the variance would result in exceptional hardship on the public, not our client Cypress Brook.
He didn't just say that there would be an exceptional hardship on the public. He affirmatively stated that his client, the applicant, did not have an exceptional hardship. What do the courts have to say about this? They twice say that the applicant must be the party with the hardship. And this is a quote from Precision Homes. The body must weigh the applicant's hardship against the community-wide flood prevention requirements. Note that it's against community-wide flood prevention requirements. They're not aligned, they're in opposition. Secondly, this says the Metro Stormwater's regulations, both provisions, referring back to the stormwater regs, require a showing of good and sufficient cause and a determination that failure to grant the variance will result in an exceptional hardship to the applicant. They make it clear this is a threshold standard. If it's not met, it doesn't go. That's what that means. And here it is in plain black and white. Variances shall only be issued 1, 2, and 3. All 3 of those requirements have to be met. Here it is broken down, and each one of those 3 variance requests has to be met for each variance. And let's not confuse good and sufficient cause, the reference to exceptional hardship within good and sufficient cause, with the standalone exceptional hardship requirement. They are different. The good and sufficient, the exceptional hardship to the surrounding communities or the others, which they don't meet anyway, but it is separate and apart from the exceptional hardship requirement. And both of these are 2 of the 3 legs of our 3-legged stool. If any one of these is not met, they both fail. Do not let them confuse you about exceptional hardship under good and sufficient cause. So here it is. Variances shall only be issued upon a determination that the failure to grant the variance would result in exceptional hardship. The words shall and should are always mandatory. This is from the stormwater regs. Shall and should are mandatory and not discretionary. So variances shall only be issued means that unless the commission determines that an exceptional hardship would result from the denial of a variance, the commission cannot lawfully grant a variance. Determining that the applicant would have a hardship is an independent condition precedent to granting a variance and not just one item in the basket of considerations. And given the applicant has admitted that they would not have a hardship, that should be the end of the discussion. But let's say they reverse themselves 180 degrees. What does the hardship statement say? They say that, among other things, that the site can't be developed. We've kind of gone over this. We can't do this. It's not true. There's multiple ways they can develop this property, just not with a 417-unit apartment complex. For proof of this, let's check what Dave Rosenberg said about the property before it was rezoned. He said, this could be rezoned, this could be used as a senior living facility. Does anybody believe that the Planning Commission wouldn't rezone this back to AR2A, I think that's what it was, T2 transect, to accommodate a different, less intensive use? Absolutely not. They pled for almost a year, if I recall correctly, to try to get a Planning Commission to approve this. It was such an intense use. That's why the restrictions are what they are.
2 minutes.
Thank you. So the hardship that would result from the failure to the requested variance must be an exceptional, unusual, specific to the property involved, and not the personal circumstances of the applicant. When determining whether an applicant has established exceptional hardship sufficient to justify variance, the local variance board, appeal board, or a governing body, that's you, must weigh the applicant's hardship against the community-wide flood prevention requirements. So the questions for council, I'll leave these for you all to ask Tara in a moment. So what about good and sufficient cause? Does their variance even meet that? A good and sufficient cause occurs when a parcel of land has physical characteristics so unusual that complying with NFIP regulations and a local ordinance would create an exceptional hardship related to the property, the surrounding property owners, or the community. Remember, this is separate and apart from the standalone exceptional hardship requirement. Specific to the property involved, not the personal circumstances of the applicant. This applies, this is a quote, it applies even if the alternative means of construction are more expensive or complicated than building the structure with the variance, or if they would require property owner to use parcel differently than original intended or build the home elsewhere. This applies even if the alternative means of construction are more expensive or complicated. In addition, the unusual physical characteristics must be unique. That doesn't apply here. There's an almost identical parcel just facing south instead of north. It's bound by the Harpeth River in a bend and also a CSX track, just like this parcel here. And this is we own the adjacent parcel. We, the HOA, own the adjacent parcel. They both have a greenway on them right now. And they both both those greenways abut the buffer, the 50-foot buffer. We own I can tell you definitively that there's nothing different that is a physical characteristic that would give rise to a good and sufficient cause. So this is proposed after dawn. So here's a quick note on the 1728040. This qualifies for agricultural purposes under the Tennessee Code. I'm out of time, but this is Tennessee Code. This is the definitions there. This is from the application's response to motion for summary judgment, where they themselves said that they used the parcel has been used for at least a decade for commercial purposes with riding lessons and clinics. So that qualifies soundly under the Tennessee Code for agricultural, where it loops in equine. So I have a lot more I could say, like Jim, but thank you for your time. Just a side note, I worked for 12 years as an in-house counsel for a company that most of our operations were on rivers, like 95% of the operations were on rivers. I find this stuff incredibly boring, and I'm the one that should find it most interesting. So I thank you guys for hanging in there, because this is painful for me. So thank you very much.
Thank you, Mr. Schultz. I appreciate your thorough presentations and the information you fed us by email. I know all the commission as staff has received it, and we appreciate your time and efforts. Okay, is there anybody here to speak in against? Any more folks in the audience? All right, with that, I'll close public hearing and ask Logan if we've received any letters of support or opposition. I know we've received a few.
There are multiple letters both ways on your tablets. I've also got a few more that are printed out if you'd like to read those, both in support and in opposition, that were sent in just a little bit late. Last meeting I read a list of people that had written in opposition. I'm not going to do that again, but I do have that list, and I also have any supplementary documentation that the applicant provided at the last meeting up here, if anybody would like to see that.
Okay.
Mr. Chairman, we reserved some time.
I'm sorry.
What was left for rebuttal?
Yes.
I think we had up to 2 minutes or close to it.
I'll give you 2 minutes.
May I go now?
Yes. Is there anything else,
Yeah,
Logan,
no,
from a
I
public standpoint? Okay, now that the public piece is closed, go ahead.
Okay, just real quick, the opposition continues to challenge the Metro Council's decision to zone this property. And this property is zoned for this multifamily project and only that project. So the suggestion that some alternative design could occur on this property is absolutely incorrect. There is no other alternative design than the multifamily pursuant to the SP that the Metro Council approved last year in Bill 2023-1968. And that bill requires my client Cypress Brook as the applicant to build the public bridge to access the property as well as Metro's property and to build this greenway. And so unlike the Precision Home case, which I think you're very familiar with, and unlike what the neighbors are complaining about, Table 6.3 was specifically adopted by this commission in your manual to address those very types of buffer infringements, buffer impacts. So we're not under the strict scrutiny of what the 3 homes that were proposed in Precision Homes to be within the buffer, to have people living in a home in harm's way. That's what that case was about. We're not at that level of scrutiny. What we're talking about are permissible encroachments, permissible features in the buffer. And in this case, these are public features. These are public facilities. My client by mandate of the Metro Council, is having to do these things for the benefit of the Metro government. And your table speaks to that as well. I could go through and really come through each variance. I don't have time here unless you want to give it to me, but I could come through and point to every instance under variance considerations in which this application satisfies those. The exceptional hardship is totally taken out of context in this political season that we just came through. I was referring to the Greenway. The bridge absolutely is an exceptional hardship if that's not approved by this body. My client can't access their property. It's the only point of access. The access they have now to Morton Mill Road, that's not going to be an emergency access. So I could go on and answer more. I'd love to answer some more questions if you need clarity. Importantly, the preserved floodplain is not impacted at all. That preserved floodplain is preserved. That provision they're complaining about and trying to throw spaghetti on the refrigerator here is not applicable whatsoever. We comply with that provision. So thank you, sir.
Thank you. All right. I want to open it up also to staff. I know we've had some feedback from staff, whether it's Metro Water Services or legal. Is there any staff comment that we should consider before we deliberate? For Metro Water, okay? Not yet. And then Ms. Sladd from legal, I know you shared a document with us. I'd like for you to, if you would, before we get into this discussion, give us a summary of that so we can consider it before we go forward.
Yeah, let me get us started a little bit here. I think without going into the full explanation of 1748, I think on its face, 1748 applies to 28, excuse me. Thank you, Michael, for your legal help. Applies to preserve floodplain. So in order for 1728 to become applicable to this hearing, you would have to make a determination if it's preserved floodplain. And as the gentlemen have pointed out, in 1728, there is not a definition of preserved floodplain, which is why I offered you other examples of where you could maybe find what that means. And really the only place you can find what that means is in your stormwater regulations. And in your stormwater regulations, it gives you the opportunity to look to make that determination by if the property has or has not been developed. And there's also a sentence at the end that's dropped in about if the property has been used for agriculture. So before we go down the 1728 rabbit hole, and we view this differently than we typically view any other variance that comes before this commission, which you guys have done 1,000 times, there's nothing different about that. I think before you open the can of worms of 1728, you ask yourself, is this preserved floodplain? That is the threshold question. I don't think that we've ever done this before. We've never had this analysis before, which is why you are the keeper of your rules. You are the interpreter of your own rules. And so before you decide to make that analysis, you need to make that determination. I would just encourage you to look at the section 5.4, just to give you an idea of what's considered there. I think that the applicant has made their argument. I think that the opposition has made their argument, and I'm happy to help in any way I can. But I think what you do when you're put in this position is you use what you have, right? And what you have is the code, and you have the stormwater management manual. So that's where I think you should start.
Okay. I'd like to just go ahead and frame the conversation, or at least a suggestion as we move forward. Let's handle that topic and then take the two variance requests if we've determined that it is acceptable, one at a time. So with the bridge and then the greenway after that. So I know Ms. Ladd had provided some aerial photographs that were part of the analysis of the code that she sent that would maybe be helpful to show on the screen if we have it. And I think what we have to do is determine whether or not this land was either used for farming or was previously developed or had grading permit pulled, and maybe a few other provisions, if you could help me with those.
Right, yeah, of course. I would direct your attention to section 5.4 of your regs, again, because 1728 is sort of completely devoid of what that means. And it really hinges on development or if a permit has been issued. And so those are the two sort of things that it looks at. So it's either developed or it's preserved. And then the way you make that determination is by reading it through. Would you like me to read it again so everybody has it? Yeah, okay. All right, so for purposes of this section, again, the top of 5.4 says you must preserve 50 feet on each side. I think the staff is prepared to take that comment on if that is being met, and that's another portion of 1728, but, all right. For purposes of the subsection, a portion of a lot shall be deemed to be developed would be that it's not preserved, if a grading or building permit has been issued, or if a portion of the lot has been disturbed by, in parentheses, approved, grading, or if a portion of the lot is improved with any material that substantially reduces or prevents the infiltration of stormwater by the total horizontal area of the lot, including but not limited to roofs, streets, sidewalks, and parking lots paved with asphalt, concrete, compacted sand, compacted gravel, or clay. Evidence that a portion of the property is developed shall include grading or building permits and/or aerial photos. Absent grading or building permits, so that's a buffer to this sentence, which I think makes it even more confusing. So that's the development piece. Now the agriculture piece. Absent grading or building permits, comma, a lot shall not be deemed developed under this section if the use of the property was for agricultural activities. The reason why I included aerial photographs, obviously I know that in most of your fields you use Google Maps all the time, or Google Earth, right? And so if you look at Google Earth, you can sort of go back. I think the furthest it goes back is 1985. I can't present evidence of that. Obviously, that's not my role, but I just wanted to give you an idea of something that you could look at and the staff could pull up for you if that was a question that you wanted to explore further.
Thank you. So just to summarize what we have in front of us are images of this parcel or a portion of the parcel in question, is that correct? And this is...
That's correct. And Steve, I will say for the record, that was provided to me by Steve Mishu.
Mr. Mishu, do you know if there was a permit pulled for these houses?
So the interesting thing in here, and this could be, up for, obviously there's a lot of confusion amongst 15, amongst 17, amongst the Stormwater Management Manual. There's a provision in here that did talk about building permits, and I was asked, look to see if there's any building permits. Interesting enough, a demo permit is an actual building permit. A building permit was issued on here a couple of years ago for demolition of these existing structures. There's discussion points on here about if a grading or building permit's been issued, and there has been recently, not necessarily for the construction of these buildings, because I think that would predate the ordinance, but post-dating the ordinance, there was a building permit to demo these structures. Mm-hmm. I don't know if that actually provides clarity or whether that just adds to the confusion of what you're looking at. I will say unrelated, but related to this case, I think we have identified that we're going to try to look at some of the 17, even though it's a code ordinance, and 15, and we will try to, clean it up at a later time.
Good, thank you. And the other components that were part of the conditions were, I think, farming and gravel roads are one of the...
Yeah, that falls under the
components.
development part, but the agriculture part is a different sentence. It's the last sentence, and interestingly enough, it doesn't just specifically say, hey, if it's agriculture, this paragraph is dead. It says absent grading or building permits, a lot shall not. So it's buffered by that, by those 4 words, a lot shall not be developed under this section if the use's property was for agricultural activities. I know that Mr. Schultz had put on the record that there was a commercial horse farm there. I did not dig into, what that, if that falls under Tennessee state law, agricultural purposes. I'm gonna go ahead and tell you guys that. I think that is, I will say it is broadly interpreted under state law, but I think what makes this different is absent grading or building permits, comma, to the sentence. But again, that's your interpretation to make.
Mr. Minshew, do you know when, you said a couple of years ago, the demo permit was filed and approved? Was that, by the applicant in part of purchasing the property, or prior to that?
So the permit application is CADM 2023-091356. It was issued in December of 2023. It says, I'm reading for the building permit application, to demolish house and barn, haul off the landfill, SP zoning, not to be burned on lot. And then it shows that the applicant was Lindsay Excavation and Demolition, not related to Roger Lindsay that works for us. And the property owner was James Fusell at that time.
And can legal clarify for us or confirm Mr. Michu's statement of demolition permit qualifies as a building permit?
I can tell you that a demolition permit falls under the section of building permits. There is a specific section in the code called building permits, and Steve probably has that. He might have his finger on that more readily than I do, but it does fall under the umbrella of building permits. It falls under that section. It's called a demolition permit, but under the code, it falls under building permits.
It's de-building, apparently. So just so I can kind of, I don't want to go down the rabbit hole, but I also want to kind of understand the timeline here. The public engagement started in 2021, based on the slides. Is that correct? So when did the applicant acquire the property?
That's correct. We started, the first public meeting was in 2021, and we acquired the property in the fall of 2023. And I will say that we owned the property when that permit was pulled. However, we had just purchased it, so that's why the old ownership was still showing on there, but that was post our acquisition of the property.
I'm going to interject here for a potential break for 5 minutes if anybody needs one. I know we're about to go down a deep rabbit hole. I'm just getting the sense of that with our three other components, and we might be here for a little while. So if it's okay, let's hit pause on this and take a 5-minute break. I think I've got some people agreeing with me. Okay, good. I noticed that. Wonderful. We'll be back at about 9:50. How about that? could read the room. So many people take advantage of that break. So with that, we have everybody. Yep. I'd like to call the November 7th Stormwater Management Commission meeting back to order. We took a brief pause as we were discussing the provisions of the code related to preserve floodplain. And I'd like to go ahead and resume that conversation. Again, I'd like to kind of pass through the gates of these three components. We've got the preserve floodplain issue. We've got, and then the two variance components that we'll handle one by one. Okay. With that, any other discussion on the determination of the code provision from the commissioners?
Well, I think we actually need to discuss if we consider this to be protected floodplain or preserved floodplain or not. There is evidence that there were buildings there. We don't know if they were serving an agricultural purpose, but the aerial imagery looks like they could be residential. And there seems to be can you pull that back up, please, Ms. Stone? Seems to be a driveway that is not just grass. So I think we have to, discuss and determine whether or not this was considered developed land or preserved floodway. Not to make more work for you, but one thing I consider wearing the hat that I sometimes wear as a certified floodplain manager. Can you pull up the 2010 flood inundation for the area? Like, you've had the maps showing the flood. So we have the floodway shown in blue and then the buffers. But just for my own curiosity, as we're discussing floodway and some of the concerns, because part of our variance consideration is the danger to life and property due to flooding or erosion and safety of access in times of flooding. So part of the reason I wanted to look at the 2010 flooding, which was an extreme event, is while it may not be designated as floodplain by the FEMA maps, can you reorder, the layers where we have the 2010 flood imagery under the floodway, the floodplain boundaries? If you need. So if you can pull the Metro ITS layers of the floodplain above that. Yes, thank you. So when we're thinking about preserved floodplain, we have the definition about developed or not, but we also have to consider where the actual designation and boundaries of the floodplain are, in my opinion, not being of a legal mindset. Based upon this, it looks like much of the area was actually inundated with the brown. So it has experienced flooding. I think we have multiple issues here, one being the development piece. And given that the residents, based on aerial imagery, or the buildings and structures look to be residences instead of farm buildings like barns or whatever. My perspective is that, one, it would probably be considered developed. And there was a permit issued in 2023. So I think we need to first vote on is it a preserved floodplain? And then I would like, as part of our variance considerations, if we do move forward, to consider the flood dangers and hazards, because that is part of our provisions for variance.
I tend to agree as well. It does say that even if, that there was a building permit, but it says, or if a portion of total horizontal area of the lot is improved, and there's clearly been improvements to this lot in the past.
Ms. Lyon, do we need to take a vote on that piece, or?
Yeah, I would. I think it's the cleanest way to do it.
Yeah.
Just if someone would make the motion that they don't think that it's preserved floodplain, and then you go back to your regularly scheduled programming, you go through your factors and you move on from there.
Okay, sounds like we're working towards a motion. Any other comments?
I think just a point of clarity, I think in looking at the imagery, and I think we're all trying to interpret imagery and site and location, it looks like it's a residence and then supporting infrastructure, fences, and a barn, and I think that's reflected in the permit that we reviewed earlier, just in terms of what we're talking about kind of being on the property. I think Ms. Camp brings up an interesting point of looking at its proximity to the floodway. Because I think it can be a little bit difficult to interpret a site that may be partially in the floodway and have other parts that are out of it. I think this one in particular, with its proximity of the structure to the floodway, clarifies that in some ways for this specific piece.
Okay. I'll entertain a motion.
Ms. Stone, can you use the select tool and select the 100-year floodplain, please? At the top, go over one, yes. Just because it is aerial imagery, I want us to be able to visualize what the 100-year floodplain boundary is on the map, because based on, so I do think it has been developed, but the other consideration is shall leave a minimum of 50% of the natural floodplain area, including all of the floodway area or all of the floodway area plus 50 feet on each side of the waterway, whichever is greater. It does not talk about the 100-year floodplain, although we see that the majority of the parcel in question is in the 100-year floodplain. So I think to kind of piece that out, one, I do think it has been developed and there's been improvements. I think the question is how much of the property is considered, or to what extent do we consider the property is floodplain? And Ms. Ladd, correct me if I'm wrong on that.
So you have to get there on the preserved floodplain. I'm going to let staff jump in, but before we get to the preserved floodplain piece, you got to get there either way. There's a 50% requirement either way, no matter if 1728 applies or not. So let's, if you don't mind, let's table that piece. I think first you make a motion, if you're ready, on does 1728 apply? And then we get to the 50% floodplain piece, and I think that staff is going to tell you basically what they've reviewed and what's been submitted on that. But I think you're on the right track. I think you're absolutely on the right track.
Okay.
So I mean, just if I'm hearing this right, because I know we need a motion and I'm a little new to this, so, but it sounds like there is some consensus that this is developed. So if it is developed, then correct me if I'm wrong, 1728 does apply?
Does not.
Does not, sorry, does not apply. So I would make a motion that we have found that this lot has had development, and so 1728 does not apply to this application.
Okay, we have a motion. Do we have a second?
I'll second.
Seconded. Any other discussion? Okay, all in favor? Aye.
Aye.
Any opposed? Seeing none. Any abstained? Seeing none. Motion carries. Okay, so that's one of three.
All right,
At
and
least.
now, without interjecting too much, Steve, would you, Mr. Mishu, could you please give a little bit of information about section 5.4?
Rebecca, can you pull up their application where they show the preservation that they provided? And while she's pulling that up, I think there was reasonable expectation that even if you decide that 1728-040 does apply, that the applicant did provide information on that they will be reducing flood danger via what we would review internally through the normal review process of a grading permit, which in this case would also include requiring the clomer, as well as going through the study that goes through it on the applicant side, plus the, not internal review, because we don't really review the clomer ourselves. We send it through Logan through FEMA, and they review it through their side, and they'll submit something to us. So there is that aspect to it. And then obviously, we do require a mitigation plan. In this particular case, it was for buffer mitigation. So, I want you guys to feel good either way, that whether you said it applies or doesn't apply, that you were going to feel good about that potentially that you were going to be able to be okay on either one. There's at least an argument presented by the development team that they do apply, as well as the equivalent on the residential side that says they don't apply. So they both make very valid arguments. It's quite interesting. Okay, so on the preserved floodplain, if we're going back into 15, we do look at the floodway, and we look at the areas adjacent to it, and we have asked the applicant to provide several maps to show that they are maintaining 50% of the floodway and the preserved area. And I think, I'm going to look for a nod from the applicant side. I think they provided not one, but maybe two or three different aspects of, hey, I'm going to show you that we're preserving 50%, excluding the future development, which could be potentially soccer fields. But then they also provided an exhibit sheet that says, including the soccer fields, which is not part of this application, that 50% would still be preserved. So, staff level, we feel that we reviewed 5.4. We've asked the applicant side to identify the areas to be preserved and provide us the maps, and we feel at staff level that they provided multiple different maps to show that they have left at least 50% preserved.
Okay, thank you for that. Since there's nothing related to the two variances that pertain to this moving forward, we don't need to make any more motions. This is for information only at this point.
Yeah, go back to what you normally do.
Yeah.
Exactly.
Okay. All right, so I'd like to tackle this one by one, and let's just go with the order that's on their agenda. So the first item is the greenway, so disturbance of the floodway and buffer to construct a 12-foot impervious greenway path and mow strip for maintenance as required. That includes the underpass of the railroad. One comment I did hear about the greenway construction is that there is no uncompensated fill in the floodplain. Can you talk a little bit about how this is going to be constructed and what the cut fill? I think I heard a negative value, or there'd be a net cut.
Yes, we have a net cut of the overall project. And so this project was modeled as a whole with the greenway, the road, all of the improvements, including the development. So every portion of it was modeled. So
I want to build on that, and this is maybe a question for legal as well, is that in reference to table 6-3, did I get that right? Which is the exemptions. I think I got that right. 6-3. It pertains to exemptions related to public benefits, which include walking trails. And in previous greenway cases that we've had come before us from Metro Parks, they typically do not come to us unless there is, and there's a specific word for this, but unless there is a,
exceptional design element.
Thank you. And in this case, I guess this is also a question for staff. If this was Metro Parks coming before us, at the staff level, could this have been approved, or does it have exceptional design elements that would need to come before this body?
We do have a resolution that allows for us to approve greenways, and they do not require variances or grading permits if it is an at-grade greenway. A vast majority of this greenway does fit that definition, but the portion of it with the bridge does not, and so that is what would have brought it before you, even if it was greenways.
So I'm trying to frame this conversation about what we should be, putting most of our focus on related to this variance request, and so that helps us narrow it down to the crossing at the railroad. I'd like for the applicant, just so we can have some more talking points to frame this. You had mentioned the outfall for the subdivision that's going to be improved in some nature. Can we expand on that a little bit so that we can incorporate that in our discussion?
Absolutely. Rebecca, can you pull our presentation back up, please? Oh, thank you. Yeah, that's good. I think I can click from here, maybe. Go to slide 15. It's not going to let me. Thank you. Okay.
Yes, this slide.
Oh, sorry.
Well, actually, it'd be helpful for you to go ahead and you kind of blew through this.
Yes.
So I want to maybe give you an opportunity to give us the mitigation elements and how we are not creating an adverse impact with this portion of the greenway.
Okay, great. So the greenway path, greenway standard path is 14 feet. However, in order to minimize environmental impact, Parks and Greenways have agreed to allow us a 12-foot path. It will narrow down to a 10-foot, 6-inch path through the safety canopy. The safety canopy is under the CSX trestle, and that canopy is to protect pedestrians and users of the multimodal path from any potential falling gravel, debris, etc. from CSX. That is the preferred method of crossing that CSX has recommended, and that safety canopy has been designed extensively in coordination with CSX and Parks in order to make sure that it is in the model, it is flood resilient, it can be removed and reinstalled easily. The maintenance mow strip for 5 feet on either side of the trail does not apply to that actual crossing because there is not going to be a maintenance mow strip there, but on the rest of the greenway, and that is a standard request to be able to maintain the greenway. The impervious area that the greenway will take up is 2.6% of the park's dedication parcel. So dedicating more than 20 acres, and this is the percentage of the parcel that will actually be impervious. The mitigation elements that we're providing here are the detailed design on the safety canopy and trail so that there is no impact, no adverse impact, and no increase in flood elevations. No uncompensated fill in the floodway or floodplain. The project has an overall net cut. We are going to maintain the Zone 2 floodway buffer area with 1.22 acres, which will be a no-mow zone. So that will be a natural riparian buffer. We have a landscape plan to remove invasive species and install southern riparian planting mix on 4.34 acres. As I know you are very familiar with the extensive root zones that come with those native species, which are currently not on the property. So reintroducing those, and the planting of 142-inch caliper trees on the property as well. So that is the mitigation proposed for that.
And then if you would give us an explanation of the improvements to the basin.
Yes. So click through this. Okay. Okay, so this is the basin you're referring to?
Yes.
Okay, so this is the aerial showing the existing HOA stormwater detention facility and where the trail is in relationship to that. So the trail is going to be located within an easement that is currently on the property and well outside of the stormwater facilities. As you can see, the stormwater facility has a pipe currently, their outfall. That outfall will naturally drain to the river the same way that it does now. Nothing that we are constructing will in any way impede that flow that exists currently. We do have an improvement here with a culvert that has more than sufficient capacity to carry the drainage from the outfall as it currently stands. And we have some pictures. Let me move to the pictures of that actual existing facility. You want to take us to maybe slide 100? Let's see. Should get us pretty close. This is the existing detention facility, and this is the drainage swell. This is the area, this is the outfall from the detention facility. As you can see, where those trees are is their outfall, and then it discharges here into the river.
Okay.
And then I have, yes, and then I have a rendering on slide. Can you take me back to slide 20, Rebecca? So this is a conceptual rendering of what that trestle would look like under CSX and the trail associated with that.
And just to round out my question, this goes back to staff. What portions of this were of concern or triggered the exceptional design element category?
Grading primarily.
Okay. And did the applicant meet your requirements in your meetings to develop this plan? Or is there anything that's different?
I'm sorry, what was the question?
Is what's shown based on conversations that the applicant has had with staff, does it reflect the intent of maybe the guidance that you provided them during the pre-app meeting to develop this greenway?
Yes.
Okay, thank you.
Shamisha,
did you have your mic's on?
If I may?
Yes, please.
Part of our purview, or what we do, is we will ensure at staff level, we will ensure that the no-rise is handled. That's part of what we do. We will also, part of our review, if they have to alter that drainage pattern coming out of the detention pond. It looks like it could use a little bit of maintenance right now, but we will ensure that during their development process, that they do not negatively impact that drainage. That's all stuff that we would do as well. And I do want to point out that I think that this is being requested not only because, I think because the greenway is more than 5 feet wide. For the disturbances to be at staff level, it would need to be like a mulch-like path at 5 feet wide. So none of the other path in this area, a lot of it's pretty paved, going all the way up to Old Harding. And the request is, because it is more than a mulch path, and it is more than a 5-foot path. So I know we're talking about necessarily maybe the bridge area, but it's also the rest of it because it's over that 5 foot. And I think the mitigation they provided and the mitigation we're reviewing is based on that additional area, not just that area for the crossing.
Great, thank you.
So I am coming into this a little late. I did watch the past meeting, but I have some questions around, so specifically on the Greenway, we are here because that is a requirement of the SP zoning, correct?
That is correct.
And so when we talk about the hardship, if, you know, the hardship on the owner is really, this is a requirement, so you have to come before this body to request this because the codes conflict.
That's correct.
So I think that, you know, we went in the circular motion a little bit with the code and where it stands versus the stormwater manual. Where does the ordinance for the billing, does that have any hierarchy? I mean, I just feel like there's like this circle because there's conflicting.
Yeah, I understand that. It is a confusing, it is a condition that was put on the applicant by the Metro Parks, but it still has to be viewed as every other variance that comes before the Stormwater Commission. So Metro is treated as anybody else. So to answer your question, the stormwater regulations would be authoritative to the SP. In other words, even though they post the conditions on the SP, you still have to find that those conditions are consistent with the stormwater regulations for you to approve it. So if you don't approve it, then they're back to the drawing board. That's the way it works.
And just another question, are these Greenway standards, I think also, because I was going to ask the same question about the cross-section, are these published standards that, or are these specific to the SP from Parks?
Parks may want to speak to that directly, but we are taking the Greenway standard and we have reduced it. Parks has agreed to reduce that to minimize environmental impact. But
Hi, Cindy Harrison with Metro Greenways and Open Space Division. We are updating currently our plan to play master plan that will specifically show all of the details for Greenways development. But consistently with all of our development, whether we're doing it ourselves or with a partnership with a private group, previously the minimum that we were designing to was 12 feet. And we've recently widened that where we can, with space permitting, to 14 feet, just because of the multi-use and the increasing use of the public, so that we leave space for both pedestrians and cyclists to travel safely across that trail. So across the county, you'll see greenways that range from 10 feet to 14 feet, and that's a factor of growth, really.
Okay, so there are standards, or is this something that is, because site constraints do sometimes impact this? I'm just trying to
Occasionally, if there's just physically limitations on space, and here we worked with the developer on the bridge portion to narrow that down so that they're able to meet that no rise. We have a few places in the city where we've got what we call a pinch point, where a trail has been narrowed down for a very short section, and then it widens back out.
Okay. Can I keep going with my questions? It's all right. I don't know if this
Absolutely.
is who will answer this, but you mentioned that the 5-foot path that is not paved, it's pervious, is not ADA compliant. Is that because of the material or the width or the slope? I mean, can you elaborate on why that doesn't meet ADA compliance?
right, so a 5-foot natural surface trail would, the type of trail material, it would have to be a mulch trail, and therefore it would not be ADA compliant.
Okay, so that's the reason, is the material.
The material.
But it wouldn't meet the Greenway requirement either.
That's correct. It also wouldn't meet the Greenway requirement.
Okay.
Yes. But it would also not require variance. So we wanted to show all alternatives and why we chose the preferred alternative because we did go through the iterations of the other alternatives as well.
Can we look at the alternative slide? Because I think a question, actually the alternative slide, the alignments, and I'll stop after this one and pause. But my question is, I know we're under strict interpretation. I did volunteer in Bellevue during the 2010 flood, and it was devastating. But I also understand that there is a huge benefit here, specifically on the greenways, and that's the only reason why this specific variance is being requested. And I'm just curious if there's a way, an alignment that was reviewed between, these were just two options, right? Is there an option between the ball field and closer to the multifamily, just because that allows parks to have access, but it pulls, I'm looking at ways to minimize impacts to the floodway.
Yeah, to build on that before you respond, I have a similar question to understand why is it placed so close to the river? Looking at how much space there is to put it and looking at its proximity to river, floodway, floodplain elevations, knowing what the fluctuation is here in this area, why place it so close?
And I think if Parks would like to comment on that as well. We did work with them on multiple alternatives here, and it has to do with the future use of how Parks intends to use the dedicated parcel.
Right, we were trying to optimize both user experience, enjoying the canopy of the tree, being able to see the river. Just overall, having some tree canopy is a much more pleasant greenway experience, but also taking into account the future use of that open space, trying to maximize our ability there.
And I'll add that this section of the greenway is at grade, is that correct?
That's correct.
Okay. And while we have Ms. Harrison up here, is there a reason why this section of the greenway has not yet been built by Metro Parks?
Yes.
Other than funding?
Yeah, a couple of reasons. We simply never had right-of-way on this property, never had an easement or an opportunity to be on the property.
Okay.
Mr. Chairman, can I just add one more point? We had emailed over the ordinance that approved this specific plan development. I want to be sure that it's part of the record, and I brought an extra copy. But the plans that are actually attached to the ordinance, so the specific plan drawings are attached to the ordinance approved by Metro Council, and they show the greenway running along the river. So we're starting from that perspective. Thank you.
And would we have that, just for the record? I want you to know that that's this 2001 document that was from the February Metro Stormwater Management Commission meeting in 2001. And this is actually related to the Harpeth Crest subdivision and the easement that exists there. Did you have another document for
Yes, sir.
this property?
There's three documents that we sent over, which was the original variance that was granted for the existing greenway in the Harpeth Crest subdivision.
I've got that.
We've got that. And we also submitted to you the Planning Commission review and recommendation on both the community plan policy amendment, which was a question at the last meeting, as well as the approval of the SP. Then we also have the actual council bill. And the council bill, and this is why I'm just piping up here, is because the council bill itself contains the specific plan details. They're details, they're preliminary. So it's a preliminary plan of development. It's equivalent to a preliminary subdivision plat, but in there it shows and depicts this greenway running along the river as, based on input from the Parks Department.
So let me build on that then. So if hypothetically, if it was Metro Parks coming before staff to construct the greenway from the existing pedestrian bridge down to the railroad, would they have to come before this commission?
Are you saying if they were just constructing an at-grade trail through that area?
Yes.
No, we would be able to approve it at staff level.
Yeah. And does that hold true for private applicants?
If a Metro Greenway was being constructed on a private property, yes, it would be the same.
So theoretically, if the applicant came to us with only constructing the greenway from the pedestrian bridge to the railroad, not crossing under it, that could have been approved at staff level?
Correct.
Okay, thank you.
I will mention, with regard to Commissioner Abbott's question about the location, we are connecting to existing greenways, which are currently along the river. So even if you choose an alternate alignment, we do still have to get back to the river on both ends to connect.
So along those lines, for clarification, there is an option B that is in the package, and my computer just like died, so I can't pull it up. But option B included a tunnel. So why is the current option being presented versus the tunnel?
Yes, during the preliminary SP process, we did present two options to CSX because, we have to cross their right-of-way. An at-grade crossing is completely unallowed per their public
Safety.
projects manual.
Yeah.
So we had a tunnel option or under the bridge option. They also told us they don't want to go over their tracks, and these tracks are actually elevated at this portion, so you'd have a really tall bridge to go over that, and CSX didn't want to consider that option. So initially, we had an option to go in the tunnel or underneath the underpass. That was in fall of 22. CSX first came back to us and said, we will consider an application going under the bridge. Then in spring of 23, working with Parks, we wanted to ask them again to please consider the tunnel option. And they agreed that they would review both options once we received preliminary SP approval. Now, we received preliminary SP approval in July of 23, went back to CSX in August of 23, and they issued us a determination again saying, we want you to go underneath the bridge. That's the application we want to pursue.
And I could probably understand the CSX preference for under the bridge because, any construction under a rail line has, danger, and they might have to stop operations for a tunnel. So I just wanted clarification on that option, why it wasn't being pursued. So it sounds like you are constrained based on CSX operations and their requirements to pursue the option under the bridge. Also, something I've been thinking about, I know there's a lot of emotions around this and concerns about the development itself, but, under our purview, we're only looking at the variance options, and should we not grant variance, then that would affect the entire project, correct? Because the greenway requirement is part of the SP. And the access by road is also part of the SP, but is that to be a bridge over the waterway or not?
That is correct.
Okay. I know we're focused on the
Yeah,
greenway.
I'd like to
so,
stay, yeah.
I'm a little bit curious, getting back to our chair's questions as to why the entire greenway area is being, why are we not why is the variance not focused only on that portion at the railroad when the rest is at grade and could be approved by staff?
I think it's related to the width and the surface. Because this is not a 5-foot natural surface, it is a 12-foot paved.
But that's, Ms. Harris, go ahead, Ms. Dunn.
I believe they could have brought two different projects to us, one a greenway at grade, but I don't believe they would want to build the at grade greenway if it didn't connect, so it came as all one project.
So I appreciate, the full consideration and what we're dealing with. I'm trying to think what my other question was. On the fill, the applicant is bringing to us saying that there is no uncompensated fill and it's actually a cut across the entire project. So that's including the development, which is not under our purview. So what is do you have the amounts of cut and or fill to create the greenway? Just looking at the greenway, not the entire project, because I feel like the actual development is kind of outside what we can rule on for cut and fill and impacts to the buffer area and flood zones.
Commissioner, just to clarify, I think it's hard to extricate the two because we're cutting in the floodway as part to kind of build up some areas of our site. And so it's hard to just remove that piece from just the greenway piece.
But if we are, as a commission, the two variances before us include, one, the greenway, and two, the bridge, I feel like it would help me to know for just the greenway portion, what is the cut and fill in the floodplain?
So the cut that we are providing is unique to the road crossing. It is difficult to portion that out because of the way that we need to model it as a full watershed. But I understand your question about isolating just the greenway. I do not have those numbers for you with the greenway isolated. Do you want the greenway and the road isolated separately? Or you're talking about the greenway and the road together?
Separately.
So I don't have those numbers.
Commissioner Kabir asked about the construction that would be involved. And so looking at the greenway to ensure that it's at grade, for the extended portion that is in the buffer zone that's under consideration, are you doing fill to construct it and have it at grade? I mean, obviously there's some cut under the bridge to construct the path there, but for the rest of the greenway, are you doing fill?
There's no fill for the greenway outside of, or along the riverbank. It's at grade. We're not building that piece up.
Okay,
there's no
so
fill.
other than the immediate area around the CSX bridge, there is no fill and no cut. It's just going to be at grade as is.
Correct. And that's for drainage, just to maintain drainage across the greenway towards the river.
Okay.
I mean, there is cut and fill in building the sub-base, but not aside
But you're
from
not
that.
changing elevation
That's
in the
correct.
floodplain?
Yeah, there's
So
no
can,
grading.
oh, sorry, are you going? You jumped in?
I was going to ask an additional question on the 10-foot 6. Why narrow it at a point that you are coming around a bend, decreasing in elevation, going under a bridge and going back up, when the new standard is 14, it's already a little bit less at 12, and then you narrow it at a potential conflict point to 10-foot 6? Why is that?
Right, so we narrowed the bridge in order to minimize impact to the floodplain so that we could have a no-rise analysis, so that we could show, because in our previous analysis, it was slightly wider, and we had a no-rise from FEMA regulations from effective to proposed, but we didn't have that 0.00 from existing to proposed. So in order to provide you with that 0.00 from existing to proposed, which is above and beyond what FEMA requires, we needed to narrow that trail in order to minimize that impact and create less of an ineffective flow area.
Okay, what if it was the standard, or if it was the continuous width at 12 feet, could you not do something somewhere else to ensure that you had that no rise? I guess what I'm trying to think about is, do you compromise potentially the safety of the greenway to get the no rise because you have to have a no rise, or should they both be equal objectives, I guess? That's what I wanted to understand. I guess I want to adhere, if it was 12 feet, how would you have to get a no rise?
you would have to compensate on someone else's property because of the way that the model runs. The moment that we go under the bridge, everything else going upstream, right, going in the reverse direction as you model, would show a rise. So you would have to compensate on someone else's property. That's what you would have to do.
And to go back to the earlier discussion, I understand the location, and I understand this wouldn't necessarily be before us as a variance, but be that it is, and be that it is we're looking at it. I guess I still have a little bit of question of why we locate it so close to I understand the proximity to the tree canopy. I appreciate that. I guess thinking about, and I know there's other locations in the city that it exists in similar conditions, but each spot has a unique site. And should it be that close, given the amount of space we have, and thinking about long-term maintenance, constructability of such thing that close to the water, and knowing what the options are, I guess I just want to understand that is the correct location if it is something that we're looking at today.
Well, this portion of the Greenway, to clarify, could have been approved at staff level.
Well,
It
can
meets-
is that true? Because I'm sorry, I am very confused. Can it be, or could it be if it was 5 feet and a different material?
Well, so we review things holistically, and what we would do is we would review very valid questions as far as the cut and fill. That's part of that's part of our normal everyday review process. So we would review the no-rise, we'd review cut and fill. We would absolutely make them balance. If they didn't balance, we would obviously bring them to the committee if they're asking for any uncompensated fill. And then as far as the greenways again, holistically, we have one project before you that has a residential aspect to it. It's got a trail aspect, and it's got a crossing to access the property. And we review that holistically. I think if you were to say, hey, how do we eliminate a lot of this greenway as part of a variance, then the answer would be, well, you've got to significantly reduce the width, and you've got to change the material. And then if you were to do that, if by chance you were to guys, the commission members were to say, hey, this is what we really, really want to do, then we are at staff now presenting to ourselves that we're going to have to go back to greenways, we're going to have to go back to the planning commission and say, hey, what was approved on the preliminary doesn't match the final, or what was approved through us, and we would have to go through the whole process again. If that's the answer you guys want to move, it'd be fine. We would just cross that bridge as we go. I think what the commission really needs to do is consider, is there a benefit to having it from a 5 to a whatever it is, and then from a mulch to a paved path? Is it worth it to the commission to absolutely have that? And is the mitigation that they're proposing, is it equal to what they're proposing to put in adjacent to the waterways, or is it not equal to it? If you guys think it's equal, then great, fabulous. If you don't think it's equal, send the applicant back to the back to their office. Let them come back with another mitigation plan and submit it before you guys.
Go ahead.
Sorry, I just have a follow-up, because, so I feel like we keep making the case that this could be approved at staff level, but to me, it's not. This is holistically a different package before us. So for me, it is impact to the floodplain, is what I'm hearing from a lot of the different commissioners, and I also see that. And so in this case, even though the preliminary SP shows the alignment, it's preliminary. And I'm not an attorney, but I think this is where the hierarchy, it gets very confusing. But final SP is construction documents. Those are the permitted documents, and that is the process in which you're supposed to work through all this detail at a technical detailed level. And so the intent is to extend the greenway, which is of great public benefit, and 5-foot mulched is not something that works in today's environment and the amount of people that use it. But as we work through this and balancing all things, are there ways to limit the impact to the flood way and buffer zones to where, to me, again, I don't, tying into those points, totally understandable, but crossing them and allowing, I mean, just to the east of the multifamily, but still allowing sufficient development of parks land seems to weigh also the issues with the floodplain in this specific area as well. So I'm just asking if that is something, I think we're all kind of asking why that's not being considered.
So if you'll pull back up the alternate plan.
If I could say, if you look at the Harpeth River Greenway holistically, it is, the bulk of it runs alongside the river. And we have 105 miles of greenways around the county. I couldn't tell you the percentage of those that are in floodways or in buffers, but I would say the great percentage of them are. And there are subdivision ordinances that provide greenway easement dedications in those particular spaces so that we can build out those recreational greenway trails.
I was going to mention that alternate trail design 2 shows the greenway hugging the multifamily. So I don't know how well visually you can see it. I know what I'm looking at because I've looked at it so much, but the trail comes up and hugs the multifamily. The reason that alternate trail design number 2 was not the preferred alternate is because the number of soccer fields that were requested, the 6 soccer fields, when we placed those in the design, then that put the soccer fields into that preserved floodplain and reduced the amount of preserved floodplain. So that's why we did not choose that alternative, but ultimately it's up to you all for consideration and while we're showing it.
But I just want to clarify, the proposed soccer fields are not part of this application. So we are.
That is
okay,
correct.
I
They
just
are
wanna
not
make
part
sure.
of this application. We just wanted to, again, show you the holistic because we know the intent of parks, and so we wanted to be able to visually represent that. But it is not part of this application.
So getting to what we actually have ruled on and considered in the past, when we do see the benefit of the greenways and the addition of that, accessibility, public good, public health improvements, those things by having additional greenways. And I understand some of the constraints of, the location. I'm less concerned, even, thinking about, flood concerns and those things. I'm less concerned about having a greenway trail next to the river because in all reality, doing the cut and fill to build the tunnel and those things could be just as impactful to the buffer zone and environmental conditions. And there may be, actual constraints because of abutments for the CSX bridge and those things that could affect that structurally cutting into that area to build a greenway trail. But one thing we do look at, and I don't think it's actually been really discussed, is I brought up the cut and fill, and we have to look at these individually. So the variance request for the greenway is one piece. So we don't, it sounds like there is more cut, no fill, and the 12-foot, concrete or asphalt path is what Parks is leaning towards being acceptable. It meets a multimodal purpose. One thing I've not really heard much about is that, and what we look at is the impacts, and Ms. Abbott brought that up. There's been no discussion about the amount of impervious area that is created based on the 12-foot greenway path and how that is being mitigated. I know there's a large, there's a discussion in the plan about 140 2-inch trees and those things, but what is the kind of the balance of the amount of impervious area that's being introduced with the greenway versus the mitigation to compensate for that?
Yes, I do have those numbers.
ultimately, we are focused on mitigating the impacts of any development in the floodplain or buffer zones.
Thank you. The disturbance associated with the trail is 1.06 acres. That's the disturbance. So the actual impervious area is slightly less than that. The mitigation area that we're proposing is 7.06 acres. Now that mitigation area is for both the trail and the road. We're not proposing two separate mitigation areas, all one mitigation plan. Does that answer your question?
Yes, and where is that mitigation taking place?
I will show you. I apologize, for some reason we're getting this black box here. I can zoom it in. So this is our mitigation, and this is where the 140 3-inch caliper trees are being proposed, also where the riparian seed mix and the no-mow zone and the educational signage. So you can see here, we have the, I'll tell you what, let me get Tarsi to explain this so that he can do a better job.
So it looks like it's on the inland side of
Right.
the greenway. Is that correct?
Right, the invasive removal and riparian mix is going on the right-hand side, which you see in purple, in between the path and the Harpeth River. Then on the inside of the trail is the floodway and Zone 1 no-mow zone. That is not a part of our mitigation. It's not included in that 7-acre calculation. And then you have in yellow the Zone 2 buffer that is a no-mow zone and is counted as part of our 7 acres of mitigation. You see the tree symbols in that 35-foot wide zone to the left of the trail. That's where those 140 trees will be planted.
I'm gonna hit a pause for another 3-minute break. Sorry, folks, had one extra cup of coffee this morning, so be right back. here. Let's see, we're missing, sorry? Yeah. Sorry about that, folks. Okay, calling the November 7th Stormwater Management Commission back to order. It's 11 o'clock, excuse me, 10:50. Let's continue where we are. Yes, Ms.
Sorry, I just have a
Alder
question. So I do think, again, I get caught in this circular because the hardship is caused by the fact that it's a requirement or they wouldn't be here on this particular one. And so, you know, in that case, it almost is like you're required to come before Stormwater before you get a preliminary SP based on the requirements. It gets very, to make sure you can meet it. If in fact we say, no, you need to realign it to minimize impacts and go out, and that forces them to go back through, right? It's this like circuitous. So all that to say, I think I propose that maybe we table this because we have had a lot of discussion on this one and move to the next. No. Okay.
Yeah.
Okay.
I'd agree with that.
Okay.
I think we've been presented enough. I mean, we've have significant information before us as to what their plans are. One of the things that we, count on is staff to ensure compliance with, from a greenway standpoint, that this meets the intent and any adverse impacts or cut and fill balance and things of that nature that we've heard confirmation of. I think Ms. Dawn had put in front of the board council resolution related to the authority of staff to give that ruling. Can you share that again or go ahead and comment on it?
This is the resolution that allows us to approve 14-foot wide concrete trails that are at grade for greenways without bringing it to the commission. Originally, we did have this, and it used to be Table 6.2, now it's Table 6.3, but there is a provision in Metro Code 206.010 that says we have to treat private development and metro projects the same unless you bring it through as resolution. So that's why we have a separate resolution governing metro greenways as staff approvable.
And just to clarify the components that I was talking about before, if this greenway is broken out into two components, the one component that we've been discussing is along the river on this applicant's parcel. That parcel does not have a, what was the term used?
Exceptional design, something or other.
And that would be able to, see, when I can't remember, would be able to be approved at staff level if it meets the criteria that Mr. Mishi had provided before us. The reason why we're talking about this as a whole is because it includes a component of the greenway that does have the exceptional design component. That is focused underneath the railroad bridge onto the easement portion of the Cypress Brook property. So really, I feel like our focus in this discussion should be maybe tailored towards that piece. So I think we've Ms. Camp has gone through some of the pieces related to the mitigation that has already been kind of approved by staff on the portion that's on the applicant's portion of the site, but now the focus is what crosses underneath the railroad. And so I think, Mr. Oliver brought up a good point and a question as to why we are necking the greenway down as it crosses underneath, and that the applicant had provided a reason for that, which was to eliminate any or to substantiate a no rise with the modeling. And that's one of the things that I want to make sure that, since there's been significant public involvement with this case, that I want to make sure that we're doing everything we can from a due process standpoint to objectively, not subjectively, objectively prove to the community that we're doing everything we can to not have negative impact to the watershed and the surrounding development. So that's where I want to make sure that we're focusing the conversation, because we've got a couple more pieces to get through as well. So, with that, is there anything else that we need to ask the applicant in order to work towards a motion on the greenways component?
I mean, I guess for me, I still think, even though there's a mitigation plan, you're putting pervious pavement within a floodway. And is there an option to realign without kicking the SP back? Because again, it shows a proposed path, but it's preliminary. based on the specific unique area and the flooding concerns.
Well, I guess we have, as a commission, approved impervious pathways in the Greenway for public benefits when there's been substantial or greater than, I guess, sufficient, as determined by the commission, mitigation to overcome the amount of impervious area that's being added, kind of balancing out that you're doing more good in the buffer zone or floodway, not floodway, but in the buffer zones to provide sufficient public good. So if the mitigation is sufficient, we have ruled that putting in greenway paths that are asphalt or concrete are allowable. So there is a precedent for that. I do think, I don't think the full greenway segment was necessarily needed to come to us. I really think the issue before us is the portion at the railroad bridge. If the rest is, the staff could have approved the rest as at grade based on the ordinance, correct?
See, that's where I'm like, but that's not happening. Like we have the package before us.
It wasn't separated
So-
because the applicant chose not to.
But, so that's true, you all could have just approved that if you break out that section of Greenway.
So I'll say traditionally, linear projects like a greenway alone or a sidewalk on an existing right-of-way would not provide detention or water quality. It would just, we review it, but we would not review it for that aspect just because of the nature of the construction. It would be nearly impossible to do. So linear project as a greenway by itself, without a huge gazebo or parking areas, would traditionally be handled at staff level without the formal things you would do for a CVS or something of that nature.
So along those lines, I do have some additional questions about the mitigation. On the plan shown, the pink area is what? Because I can't read the text. That's the no-mow zone.
The no-mow zone.
Okay. All right.
Then the yellow is within floodway buffer zone 2. So all mitigation is occurring within the floodway buffer.
All right.
One thing to that, and nothing's being disturbed within there during construction other than the greenway path.
That is correct.
And just to add on to that, the existing conditions of this proposed path is through a wooded area, or what are the existing conditions?
Pasture, like,
Pasture lake, so, okay,
Yeah.
no trees.
no trees, no native grasses.
So my question on the mitigation, while the mitigation area that you report will be done for both variance requests in totality is 7.6 acres. You have also talked about holistically and long-term the potential for the soccer fields. Will the soccer fields not impact that buffer area in the future?
So I do have an illustration of that.
And my concern on that is if it is anticipated in the future that those areas will be converted to soccer fields, that lessens the amount of mitigation you're actually contributing.
It does, and so we have a plan that shows that, which for some reason isn't showing it, but you should have it in your package. It does decrease it slightly. We still have more than twice the amount of mitigation area, but I do believe it is 6.28 acres as opposed to 7.06 acres of mitigation area. So we still have more than twice the mitigation area of the disturbed area, but it does reduce it, that is correct, which is,
If that happened down the road, though, I assume that staff would be reviewing the proposed plan by Parks to ensure that it's not affecting previously approved mitigation for a variance like this. Is that right? So there wouldn't be a condition that the mitigation would be impacted without dual compensation?
That is why we wanted them to include the soccer fields, even though they weren't part of this initial variance, because we did know that that would reduce the amount of area that they were proposing as mitigation, and we wanted that to be before you at the time.
Thanks to staff for including that.
So I'm sorry, I feel like I'm catching up a little bit. So there are no existing trees in the proposed greenway, and so, but there will be trees planted to the east of the proposed greenway between the river and the greenway, or to the other side, to the west. So I'm just trying to.
There are existing trees between the Harpeth River and the proposed trail connection.
So I guess I'm just trying to weigh here, right? We have a location, and I understand that, if it was picked for the view sheds, but there are no views, I mean, we are also weighing, this committee really just weighs the impact to the area, the floodway and the buffers. And again, they aren't separate. And so, I know there's precedent, but I guess I'm also wondering, in that precedent, were there alternatives that could easily be relocated? We're dealing with a very big piece of land. And so I'm just trying to make sure we vet all alternatives. If, in fact, there is no view shed to the river, if you build it along the river, it's.
There are a few breaks in the tree canopy where there would be some view sheds. And the idea is that removal of invasive species along this area so that we can further establish the riparian seed mix that's being proposed along that area.
So there is disturbance in the.
There is no disturbance.
Just removal.
Yep, it will be removed. No disturbance to the soil. We'll be using techniques that will not allow for disturbance. No mechanical removal.
Okay, thank you for clarifying.
The SP plan does approve the greenway in its location that's proposed. So
The preliminary.
If we change that, we have to go back through, y'all have to go back through submission.
No, not,
I mean.
we would not have to go back for an so let me go through the alternatives one more time here. I believe that's around.
And while you're finding that, I'll remind our commission, it's 11 o'clock. We've got another hour, so we've got another component to get to. I hope we're working towards a motion here soon.
Is there any way to not do the motion and talk about the second piece, or you are?
No, I think we need to resolve this greenway piece. It's completely separate from the bridge.
Mr. Lewis,
Can I just maybe close out one of my questions that I had? So greenways is okay with reducing the greenway to 10'6" to achieve their no rise that they need. You're comfortable with that reduction underneath there?
We are. If we build this greenway trail, if it was Metro Parks, we would be dealing with the same issues, right? It's not unusual to change the width of a greenway to accommodate space restrictions. Holistically, we try to keep a 12 to 14 foot wide trail, but there are conditions, because we're in the outdoor space, that we have to adapt. The public likes, the experience that the public likes is seeing the river, and there's educational benefits to that, or being in that riparian zone, and designing it in a way that protects that area, and putting easements or owning property as a Metro Parks protects and conserves that open space, not only the riparian zone, but just the whole open space. There's a lot of value to that. The view of the river is going to change depending on the season, right? Most of those trees, I would say, are deciduous. Removing the invasives is a benefit to the quality of the river and of the open space. So that changes. But there is, I think, a lot of public benefit in addition to the trail of bringing people into those areas, educating them about the importance of healthy riparian zones. the recreational aspect, the multimodal transportation around the city, and the precedent that we've set across those 105+ miles. Like I said, we're in those spaces that we have an ordinance that allows us to be in those spaces.
And if Metro was to build out that connection underneath as its own separate project and complete this Greenway connection, would the no-rise study still be required as a part of that work if there wasn't anything else associated with it?
I believe it would it not?
You know, if you're doing that at grade and you're not really altering it, I mean, there's a coefficient for a difference between grass and pavement. Usually the at-grade ones, where they're not increasing any fill, or if they're not losing any volume in the floodplain, then once again, linear projects are usually pretty golden.
Commissioner, I would also like to just remind the commission that in the September meeting, the interpretation of the regulation was that no increase in flood heights, period, versus effective or existing could be allowed to authorize a variance. And so that's the interpretation that we took to make sure we had that no rise, because we need a variance to go under the bridge, period, then we need to have a no rise versus effective and existing.
I'll remind, since we're working towards a motion, whoever's going to make it, if it is in support, to include the conditions that Greenways had in their statement.
I think I think that's not, binary, right? It's not 0, 1 and proven, not approved. In my mind, I still think we can hit the multimodal and do all the things and look at an alternative alignment, weighing all the characteristics of this specific property.
Okay, so the challenge in that is there are different site conditions at play and constraints. So since they're separate variance items, we tend to take those separately just to keep it cleaner, because we could approve one variance request and not the other, or approve or deny both. So I think that's the reason for taking each individual variance request separately.
Do you have, is there a reason, give me some of the pieces that you're concerned with.
Minimizing impact. I mean, if they could come across, again, you'd have those 2 tie-in points. It would basically be designing alternative B.
So we do have that alternative before you. So alternative trail design 2 shows a trail that goes along the multifamily.
Yes.
And is not in the floodway or the buffers.
Okay, I'm so sorry. I was mistaken.
Okay.
I thought this was actually along the riverbank. And
So
I think, is there another, okay.
The variance request,
Yeah, it's very,
and
sorry.
their preferred option is to put the greenway along the riverway, but these are 2 alternative trail designs that do not affect the floodway and buffers.
Right. So, but the variance request showed it along the river, and so, but there is an alternative too that could be approved.
That we have provided you with the preferred alternative, which is the alternative that Parks and Greenways is supporting, which is along the river. Okay. We've also provided you with alternative design 1 and alternative design 2, which show some different alignments. And the explanation of why we chose the preferred alternative is because the intent is that Parks would like to build out soccer fields in the future, and those soccer fields would then be shifted into that zone. And so the preferred design actually has the largest preserved floodplain area. So the preferred design is the lowest impact to the total preserved floodplain, but it does have the trail going into the buffer. These designs show the trail going outside of the buffer, but you can see in trail design 1, there are less soccer fields that can be constructed. And in trail design 2, if you construct the same number of soccer fields as in the preferred design, which is 6, then you decrease the amount of preserved floodplain.
Okay, just for clarification, we have already ruled that it's not preserved floodplain, but we do need to protect the flood zones. And
That is correct. We just provided that calculation to show environmental impact. So you can choose a different design.
Sorry, I have a question for Parks. While we know what you have endorsed essentially as the preferred design, which is the trail to go along the waterway, one concern I have is, and I'd like to hear your opinion on this, thinking about future potential build out of these soccer fields. I know you want to optimize, playing area and those things, but what is the anticipated means for people to access the fields? Because I don't see parking lots and those things, and it looks like, for individuals to be coming to those fields, they would park somewhere in the development area or be accessing by trail.
Just across the existing pedestrian bridge is ample parking. There's soccer fields on that side, so it'd be a continuation of that. I don't know how intense these fields will be in terms of times of usage, whether they'll be practice fields, which is what we have there at the tip of the bend now. But the parking is on the other side via that pedestrian bridge.
Right, I'm asking about parking because depending on the placement of the greenway, that could affect, additional development,
Sure.
Parking,
Well,
and access to the
and in
fields.
addition, we have the 51 acres that we'll be able to develop because we'll have access via that bridge. And it too will have parking. Now, parking to specifically serve soccer, no, it's parking to serve that park, but there will be two parking areas provided there.
Can I ask a clarifying question?
Yeah, but I'm going to remind you, we got 50 minutes. We've
Okay.
got to come to a motion.
Okay, so as it relates to alternative to, when you say that has the most preserved, that's with the future build out when you're looking at the park. So if you're just looking at the impact now to the floodway and the buffer without anything to do with soccer fields, so the application submitted, which alternative impacts the floodway and buffer the least?
That would be design 2.
Okay, and I guess my question is, when the soccer fields or whatever facilities Parks brings, that would be a separate project that would be brought before Metro at that time and would be evaluated. Is that a correct statement?
Absolutely.
Okay. I have a motion I'd like to make, but
Please.
okay, I am sympathetic to the process in which the developer has gone through, and I do think there's a lot of public benefit, and I know it's not linear, the process, so, but in this case, I am inclined to make a motion to approve with alternative trail design 2 alignment.
We have a motion. Is there a second? Okay, seeing none, motion does not carry. Okay. I'll entertain another motion.
I'll make a motion to deny the variance for the greenway as designed with the recommendation, I don't know if I can find the recommendation, but the condition that the applicant, wait, if we deny, they can't come back with a new design, can they?
This is a final.
I will make a motion that we defer and the applicant presents a alternative design as the preferred design to minimize impacts to the floodplain and buffer zone.
Okay, we have a motion. Do we have a second?
So if we defer, and if the applicant can choose to not have a deferral, but if we defer, they can come back with a request to approve the alternate design.
But can we not, we can't?
We cannot approve
Oh,
an
I
alternate
see.
design
I
because that is
see.
not what is presented as the variance request. That is just for informational purposes of hardship or additional considerations.
even though it was part of the, okay.
It's part of the package, but is not what the request for variance is
Right.
for.
Correct.
So just for point of clarification, if there are multiple alignments, you need to present those as 1, 2, and 3, or no? You have to pick
present
one.
the preferred as part of the variance request. The others are just for informational purposes to demonstrate why one is preferred and the focus of the request.
Thank you.
Wait, I'm sorry. I think you can make a motion to deny as submitted and to approve an alternative, if that's what you want to do.
But they don't have the mitigation done for that alternative.
But they don't have the mitigation done for an alternative, is what you're saying?
Right.
Okay.
But just in this case, though, I mean, it is the most minimal impact, right? Because they're going 90, and so could you say you approve with the, no, okay.
Okay. Parks, they've
Well,
already,
sorry, we have a motion. I want to make sure we have a second. Is there a second to this motion? And if not, we can
I
carry
have a
discussion.
second.
Okay, we have a second. Cast a vote. All in favor, say aye.
Aye.
Is that 2 in favor? Or is that 2? Okay. Any opposed, say nay or no? No.
nay.
Did you vote or abstaining? No, okay, so that's 3 to 2. Motion fails. All right, I'll entertain another motion.
Okay, a motion to approve is submitted.
Do we need to include the conditions from Greenways?
Yes.
Any other conditions, Logan?
I don't think so, unless
No.
Mr. Mishu's got anything.
Okay, we have Mr. Mishi.
Are you suggesting, which version are you?
As submitted with
submitted
the
version.
comments from Greenways.
Okay, is as submitted, not alternative trail design 1, not alternative 2. Please, Ms. Rebecca, can you go back to the original one then? And then I'm assuming you're saying the original one, however, with the shortened trail width was.
No, it's as submitted, it was 14, and then it shrunk down.
Came down to 10.6 at the cross.
12.
Or excuse me, 12 to 10 and a half or something, to ensure there was a no rise with the stream.
I feel we're saying the same thing, just in a different way, maybe?
Okay.
But this really raises a great question, because I want to ensure that we as staff understand exactly what you want from us to ensure happens
Oh, okay.
after they leave here.
Greenways had a list of conditions on their review that I want to make sure are recorded, since it wasn't part of what the applicant's packet.
So what is shown on this screen, however, with the conditions that Greenways had agreed to, which includes the shortened width.
No, go ahead, Miss.
The width is part of their package, the reduced width.
Okay.
There are conditions that we added that specify in the remediation and the planting, those conditions of how those trees are maintained until we take over ownership.
Okay. Once again, I
Good
just want to
clarification.
ensure that it was
Yeah.
clear, so that way we could enforce the wishes of the commission.
Those were listed in Parks staff comments.
Yes.
Yeah.
Thank you.
All right, we have motion, was it seconded? Sorry.
I don't remember the second
Okay,
for
yeah.
that motion.
Okay, we have a motion to approve with the conditions that Greenways had stated in their analysis. Is there a second? It's been properly seconded. I'll cast a vote. All in favor, say aye. Aye. Any opposed?
Nay.
2 opposed, so it's 3 to 2. Motion carries. All right, that was the first of 2, and so the second one is related to the bridge. So let's dive into that one. I want to kick this off with a conversation about the alternative design that you all had done based on the feedback we gave you in our last meeting related to ensuring no rise or adverse impacts. And can you please expand upon maybe 2 or 3 of those prime components that will help drive our discussion?
Yes, so in our previous submittal, we, of course, did take your comments into account, and we did do a redesign of the bridge. So we changed from a 5-span to a 3-span. We also changed from concrete girders to steel girders, which allowed us to raise the low chord of that. And we also skewed the abutments so that they are now in line with the flow and reduce the ineffective flow area. So all of those improvements did result in a 0.00 across the board in all models. And we have details of those.
It's also 35 feet longer from the one that was presented at the last meeting. So it was 500 feet exactly, and now it's 535 feet.
What was the purpose of extending the bridge width?
It was to move the abutments even further outside so that the water's not touching.
Can you approximate the distance from top of bank to abutment?
It's a little over 500 feet.
From top of bank to abutment?
I'm so sorry. From top of bank. So what you're talking about is the actual channel, right, itself. We can probably do the math here real quick.
Just an approximation.
Well over 100 feet from the abutment to the actual top of bank.
On both sides?
Yes.
Okay. The other issue was the angle of the bridge, and I think there was some conversation about modifying it to ensure no rise.
Yes, so we did have multiple SKUs. Thank you. We did have multiple SKUs that we worked on here with the alignment, and here they are right here. Brian, I'll let you discuss that.
Sure. These are just two of them that we wanted to present that were the most viable. Both of them went to a 3-span structure, just like the one that we have before you today. Both of them got slightly longer. They both approached Coley-Davis at less than desirable skew angle for traffic then to make movements onto Coley-Davis, and both showed a rise in the water surface elevation.
Okay. Those are my starting questions. Thank you. I'll open it up.
Okay. So speaking of alternatives, which we have belabored multiple times here, I'd like to better understand the situation with Morton Mill Road and the potential for coming in there. My understanding is that it seems like as part of the SP, you are required to create a new access point to the property for the development. Is that correct?
That's correct. I should be able to answer these questions, but go ahead.
Okay. So that is a condition of the SP for the development, is to create a connection to Cooley as opposed to Morton Mill.
Yes, it absolutely is.
Okay.
The current connection to Morton Mill Road is an access easement that has served that property since the railroad was there. So that crossing is preferred by the community and obviously by Metro Council now to be converted to an emergency access only. So there will no longer be full access, as it is now, full access to the terminus of Morton Mill Road. And so in place of that, this bridge to connect to Coley-Davis Road is the preferred route. And one other point why that makes good sense is because this puts every occupant within this development site within a half mile of the interstate, as opposed to driving almost 3 miles all the way down Morton Mill Road to come all the way back to get to One Bellevue Center, for example.
Okay, access to the interstate is not a consideration for our commission. It's more safety and preservation of, the floodplain and buffers. So I'm trying to better understand the need for the roadway for the development and alternative options for access.
So the bridge is a requirement for this project. Metro Council did not want to have this property rezoned in a manner that intensified the development and leave access only to and from Morton Mill Road. So the community plan amendment. The community plan amendment that was approved by the Planning Commission is conditioned upon this bridge being in place. If the bridge were not built, the community plan amendment would revert back to what it was, which was a rural recognition of the long-term use of the property. So the Planning Commission and the Metro Council said apartments this close to the community across the river, just to the east here, that whole Bellevue Center, apartments in that close proximity to the existing development is appropriate. They agreed that it should be a suburban level policy conditioned upon the bridge.
Can I ask a question about CSX as well? So can you just remind us, they did not want, would that, I guess, I don't want to put words in your mouth, but the existing condition would have to be improved in such a way that would CSX approve it?
So the issue is that that's an at-grade crossing. You know, CSX's policy is to shut down as many at-grade crossings as they can. And because of the age of this crossing, there wasn't an agreement in place previously. There's actually multiple neighborhoods in this area that have the situation where they were just predating this formal crossing agreements that CSX now requires. Now, for any change of use, period, CSX would have to evaluate the need for, I guess, the amount of traffic that would be crossing it. And in their mind, any sort of increase in traffic was something that they could not support. And so the reason why we were able to get emergency access authorized is because we're reducing the use of that crossing and hopefully eliminating it altogether, just besides unusual emergency access.
So can I just, so you have the approval to build the apartments, but CSX says no. So if you don't build the bridge, you have no access point.
Well, CSX approved the emergency access with the understanding that the bridge would be built and provide access to the property instead.
That is correct.
You have no
Without building the
access.
bridge, you cannot develop the property because CSX will not allow you to improve the existing crossing. The at-grade crossings are a safety concern for CSX, and they're trying to eliminate them.
Can we talk about the hardship for a second? Go ahead. Oh, sorry, I didn't see your mic.
That's exactly where I was going, is
Go
to
ahead and ask it.
understand we need to clearly understand what the hardship is in this particular variance. I'd like for you to clearly articulate what the hardship is as the applicant.
Yeah, and it's been covered also in the submission, of course, but the condition is that this bridge be installed to serve the development of this property. This property is landlocked, but for an easement to Morton Mill Road. Similarly, with the Metro property next to it, the 51 acres, similarly landlocked, but for the access across this bridge to Coley Davis Road. So when you think about the exceptional situation of this property location relative to any others, and there's people suggesting that, well, there's nothing different about this particular site than another bend in the river. Well, that's not true, and I'd like to go through some of those factors if I could. If we were just to compare this bend, and I don't know if we have a really good photo or exhibit of it, but this property is located south of the river, north of the railroad tracks. The immediate bend next door is across the river, and this is the Scenic River Farms single-family development. It's been referenced in submissions to you as the Howes Bend. That property is on the north side of the river and crosses the railroad track at a crossing to get out to Coley Davis Road. The apartments here are outside the floodplain. The property just on the other bend to the west is within the floodplain and consists of homes that are within the floodplain, including septic fields that are in the floodplain. This property is not crossing the CSX railroad. So if you imagine that based on the zoning approved for the property, if we had all the multifamily development crossing over that CSX at-grade crossing, that's not something that they want to see. That's not something they've approved. So it's emergency access only. So the hardship here is the physical fact that you cannot cross the river without the bridge, without the variance for the crossing, and you cannot get permission from the owner of the railroad track to cross the railroad track under the current easement. And so, it's one or the other. It's really there's not an alternative means. The experts can talk about other bridge positions, which they've done, but this is the only feasible location for a bridge to access the property. The other aspect of this, which I think is important, This is not just a private bridge. This is a public use bridge. The other properties, the other bins that we're talking about, they don't have that situation. I mentioned the secondary emergency access, and so again, the exceptional hardship and something that really begins your evaluation under variance considerations is that you're to look at all technical evaluations and all relevant factors. The things I'm speaking to you now are the relevant factors, the rational, reasonable factors. If my client can't get the bridge across the river approved by way of a variance for you, they can't develop the site. So then we're in a situation of where they're prevented from developing the property as it's presently entitled by Metro. And so the very last consideration, you've got the exceptional hardship provisions, and the other is that a determination that you need to make that the variance will not result in several things, but including conflict with existing laws or ordinances. Failure to, that granting the variance will not result in a conflict with other laws. Failure to grant this absolutely conflicts with the law that applies to the property, which is this SP, which is Bill 2023-1968. So the variance, in my opinion, is necessary and absolutely reasonable. There's that rational nexus that it has to be done in order to develop the property pursuant to the ordinance that was approved for the property. Without it, you can't develop the property. So all of those relevant factors are put in the mix of the technical evaluations from the engineers here as to why that variance is necessary.
I think a couple points to clarify is that the previous planning process determined that the site was appropriate for the zoning being requested, but they don't necessarily look at it to say you can access it and build what it's zoned for. And so I don't think not being able to build what a property is zoned for necessarily creates a hardship, because you have to have this access to fulfill that, because it would be developable just in a different zoning classification. Second point that I would like to make is the reference to the access to the piece of parkland. And the question I have related to that is, it appears the vast majority of that property is within the 100-year floodplain. So I guess I would be curious as to if Parks has any plans for what that property would be other than a natural area that could be accessed from the pedestrian bridge that currently connects across into the pathway there. So I don't know that I fully understand the explanation that this provides access to a piece of parkland that may, based on its current configuration and what lies within it, appears to be natural parkland, and unless there's some development plan that would speak to a different scenario.
So you heard Ms. Harrison moments ago speak to the access drive that will be platted as part of this property, and it's depicted here on the screen. Mm-hmm. So in the cul-de-sac, in the roundabout, there's an offshoot of a potential street running in directly into the 51 acres. That would be used by Metro Parks for potential parking area on this side of the river. They presently do not have any parking on this side of the river, and they can get to the fields that they would like to build by way of the pedestrian bridge. This bridge, being a public bridge, will give the public access, better access, if they want to hike to the 51 acres, or frankly get on the trail that's already there. So the trail that's there, you can see sort of curving around on the other side of the bridge. That trail's there now. And so it gives better access to the community to get on to these public facilities.
Can I ask a clarifying question? Because CSX, so even if no apartments were built, you dedicated this land to parks and they built a number of ball fields, that's going to increase the number of people. So you've had lots of conversations in CSX. I just want to make a clarification. They've said no increase. So,
that is correct.
So nothing. So you basically don't have an access point unless it's I guess I'm just
That's
curious.
correct.
So Parks wouldn't even be able to put anything there?
That's correct, yes. CSX will not allow any increased
I think we have to
access.
be careful evaluating potential scenarios as opposed to evaluating what's before us.
I think
right now.
I'm trying to figure out hardship, right, and access. So you don't necessarily have access to something that is owned, that is deep, so they have to build the bridge to have access. That's where I'm like, that's the hardship?
But the particular hardship that's been communicated is that it's required based on the density that's been zoned and that is desired to be constructed. If the CSX easement is there today, assume you could continue to access the house and property that's on it as a part of the purchase. So because they won't allow you extra vehicular trips over the bridge for a more dense site, I don't know that that's a specific hardship.
Well, there's no easement, you said,
There
correct?
there is an easement
verbal.
currently for a single-family single-family residential, which has,
Sorry, misheard.
which is no longer present.
me
So
take this back.
the site cannot be developed for more than one person to live anywhere on the site or for public to access the properties. But I do also want to mention that the bridge is also a safety concern because if Morton Mill were blocked, the bridge does provide another access, vice versa if a portion of Coley Davis were blocked. So there is that additional access piece there for public safety through that. Also, even though we're not requesting a variance to raise Coley Davis, part of the agreement for this bridge is to raise Coley Davis to the 500-year floodplain. We are doing that without the need for a variance. However, we do know that there is a history of Coley Davis flooding, and so raising the elevation of Coley Davis to the 500-year floodplain is a significant improvement to the community and to public safety and welfare, which would be a part of building this bridge.
Go ahead, Mr.
I
Lewis.
was also going to clarify that the bend is a man-made bend. It's not the original river.
That is correct,
So you're
and
not so any bridge disturbance is not disturbing the original natural
that is correct.
configuration of the property.
And a bridge itself would be approved at staff level. The reason we're before the committee is because of the skew. So we're at a 28-degree skew instead of a 15-degree skew. And the reason we're at a 28-degree skew is because of this very unnatural bend, which is specific to the site characteristics of this bend. If this were a more natural bend, then we would have been able to cross it at a 15-degree angle without causing a rise. Because of this unnatural bend, now we have to have a 28-degree skew, not a 15-degree skew, which is why we're before the variance committee.
I'm going to make a quick thank you, and for clarifying that, because it helps us bring us back to what we've been asked to do, which I want to remind the commissioners, 'cause I'm also watching the clock. The applicant is here before us today, not for whether or not they can or can't build the bridge. They're here in front of us today to ask for a variance for disturbance of the floodway and buffer to construct a vehicular bridge at an angle greater than 15 degrees and within 1,000 feet of a pedestrian crossing. And so I want to make sure that we focus our conversation on those two issues and work towards a motion related to granting or disproving a variance. I appreciate the applicant bringing that back to center of the angle that's being requested is 28 degrees. Okay, and the reason why it's in this location, the 1,000 feet of within 1,000 feet of the adjacent bridge is based on roadway alignment.
And off the property. The furthest distance we could get on property that we own is the 785 feet.
And how many feet are we from, or within the 1,000? How many feet are you from your 785 feet? So you're 7,580 feet. If it was 1,000 or more, and if it was at 15 degrees, this bridge can be constructed simply by just getting an ARAP. Is that a correct statement from staff?
That is correct, which we already have.
It would be through the proper procedures of getting the ARAP plus the no-rise.
So what we're talking about here in this meeting for our variance approval or disapproval is a 13-degree variance and whatever the quick math is on the 115 feet off of the 1,000.
215.
215, yeah, I'm sorry.
Math, yeah.
Thank you. Engineers, you think we could do math quickly? That's right. Okay, so I want to frame that back into context so we can kind of work towards, again, a motion related to those items.
So I do want to make, just bring to the forefront the fact that we are not required to settle this in today's meeting. I know you're watching the time, but this is a complicated issue with lots at stake and a lot of engagement from both the opposition and those in support of this. So I do want to make sure that we're not rushing this and give it its true due diligence as we consider it. I am struggling with the hardship piece. I understand that part of the SP zoning, it requires, for the development, requires the bridge. However, hardship is not the financial hardship of the applicant to profit on developing a property. That has been something we have ruled on before, a financial hardship of not being able to develop in a property that an applicant wishes to do so. The financial hardship is not cause for us to grant a variance. On the hardship piece, while CSX is not amenable, based on what you say, to an at-grade crossing, I understand, because I have worked in the transportation space, I understand the safety concerns with that. However, I am not seeing an alternative. Yes, Metro Council has issued, or zoning has issued an SP with the condition of putting a bridge. But I have not seen any discussion or presentation of an alternative where there's a tunnel under CSX and maybe a widening and improvement of the Martin Mill Road as a feasible option that would not require a bridge, would not require encroachment on the floodplain and buffer zones. I think that's something, it would not result in an at-grade crossing, but it's also not as convenient, but it would also allow access to the property outside the hardship that's been suggested.
If I may, just very quick. The community that lives along Morton Mill Road absolutely does not want this traffic coming down Morton Mill Road. In fact, several amendments to the bill restricts the amount of construction traffic, et cetera, et cetera. So the idea of either tunneling under CSX at the end of that cul-de-sac that's there now, the track is elevated to do a bridge up and over. You've got TVA lines to deal with. It's extremely complicated, and the engineers can address that. My client's not asserting a financial hardship here, not at all. And I want to just quote from Precision Homes case, which I know you all are very familiar with. Overall, the FEMA guidance is similar to the Tennessee case law in that the emphasis is on the peculiar characteristics of the property itself. You all have been looking at the maps here. The hardship that would result from failure to grant a requested variance must be exceptional, unusual, and specific to the property involved. There's no other property like this. There's no other property that we're aware of, and maybe you aren't either, where the requirement is the only way to get to it is to build a bridge. It's a public bridge. It's a multimodal bridge. We got the WeGo system just on the other side of the river, and a greenway that's the missing link in existing greenways. So when you take in all the relevant factors, which is really the preamble to what you look at for variance considerations, there's no other property like this. It's unique, it's unusual, it's peculiar. And the idea has been floated with CSX. Mr. Moda can explain all the dialogue that was accomplished with CSX on how to deal with this particular easement or getting over their tracks. So I just wanted to make those comments. Thank you.
Right, but the size of the development is what results in the amount of traffic, correct? So a smaller development might be more amenable to CSX for a crossing.
I mean, we are approving greenways, right? And we had this conversation about the soccer field. So, and I don't know if this is proper to speak about here, but Metro Parks could be coming in and asking for the same thing, and they won't have access from CSX. So it basically landlocks the site for any future use outside of one single-family home. And I don't know the legality of that. Since this ordinance has been passed, it has been rezoned. And going back to the skew, I guess, we talk about the skew, and I watched the video, you asked them to make changes to minimize impact, which are costly, very costly. And I feel like they did that. And so I'm inclined to say, that this is a public benefit, and the hardship is almost the distance to the pedestrian bridge, really. But outside of that, and the unique characteristics of the site, I make a motion to approve the variance.
Okay, we have a motion to approve, and I heard a second. Is there discussion?
I think the hardship hasn't necessarily been clearly communicated in terms of, because I think you can't really look at scenarios to determine if the current hardship is applying or not. From what I understand and would seek clarification from the staff on this, if the bridge, if someone that owned this property came forth and said, we'd like to build a bridge from Coley Davis Road to this development, and it was within the 15-degree alignment of Coley Davis, that would be a staff level process that would be reviewed and approved. Should they submit a no-rise study? Should they do whatever the requirements are that we're seeing here today?
That's a huge if, that they provide a no-rise.
Sure.
I think what we had, I thought internal staff was thinking is that the more they get to closer to 15%, the more likelihood that they will not have a no-rise and it will start to become a rise, which would once again go before the committee. So I know if there was a no-rise and it was perpendicular or within 15 degrees, you're absolutely correct. Now, can you do that 15 degrees with a no-rise? I do not know, because that's just not information that's before me.
Yeah, and that's not necessarily what I'm asking. From what I'm understanding is that because of the location of Coley Davis and because of the location of the Harpeth River, it creates a very unique circumstance of having to cross it, whether it was for this or something else. But if that request came in and it was 15 degrees or less, then it would be something that would be staff approval. The unique thing that we're looking at is because it's beyond that 15 degrees, and it's beyond that 15 degrees because Coley Davis, NDOT wants it to intersect and create a safe intersection at this particular point for it to cross, and that's what's driving the 28 degrees.
And it's only before you because it's over that 15 degrees.
Right.
Oh, sorry. The 215, which is
the distance.
And the distance.
The distance,
yeah.
right.
I don't want to murky the waters, but that 1,000 linear foot rule came because we had a development that had a zigzag in the stream, and they had multiple crossings within 1,000 feet. And they came in for a variance, and they came in for another one. We're like, hey, wait, what's going on? And then we asked them for a bigger story, and we found out, hey, they were planning multiple, which wasn't what we were preferring. So that's where the 1,000 foot came through. I know we have asked them to say it's within 1,000 square feet. 1,000 linear feet. If there was an existing house over here, an existing house here, and they both had crossings, and a individual came in, wanted to build a house right in between it, we would not make them come to the committee because they're existing crossings, and they're not proposing multiple crossings within that 1,000. I wanted to give you the background, but just for the sake of the discussion, we had asked them to include that in there, just because there was enough gray to want to include that in there.
Can I ask a question? Is access not a hardship? Because we, as this committee, are not here to approve what they're developing, right? It has been approved as multifamily, and access is that considered a hardship? So
I think you have to look at
based on all those, I guess what I'm saying is based on all the circumstances, this is how they access the site. And we have asked them to show evidence and they've made changes due to the impact. So that's where, I guess, if there's questions on hardship.
So I do think access can be a hardship. The question is, are there viable alternatives to what's been proposed? And have those been fully presented based on our guidance that they're looking at the availability of alternative locations not subject to flooding or erosion damage for the proposed use?
But I guess they have talked to CSX and they've talked to NDOT, which really are the experts, I think, on their facilities and access. And this is the proposed access point based on
We
that.
also do not have documentation from CSX stating exactly what the limits are, do we? I haven't seen them. So we're going off of the applicant's conversations with CSX, not CSX having written documentation saying we will not
submitted, during the preliminary SP, we submitted documentation to planning staff to substantiate the fact that we could only have emergency access. That was a big concern from the community, to ensure that we could actually commit to even providing emergency access. And so that was something that planning staff had required of us, and that's something we had submitted, and we could submit the preliminary approvals for that emergency access, but CSX has never issued guidelines in terms of what they would
So the preliminary SP is based on conversations and some information provided about CSX limiting access for emergency only, but no alternative has been, like a tunnel or whatever, has been presented and approved or disapproved by CSX.
Let me remind you that the neighborhood doesn't want that either. So again, we're looking at all these circumstances.
But I also want to make sure we're not just going based on what they say, but actual documentation.
I mean,
if I may, the council member, at the time, Councilmember Rosenberg, I mean, he would not consider the proposal with traffic from the development going through the Morton Mill community. So that's why a tunnel option was not discussed with CSX, besides the fact that we had, besides any consideration of cost or anything like that. It was purely because Councilmember Rosenberg did not want traffic from the development going through the community of Morton Mill Road.
So I think, when we were here last time, we heard what you said, we heard what the community said, we did take that back. As has been previously mentioned, a bridge is an allowable use. A crossing is an allowable use. What we're requesting is for the skew and the proximity to the pedestrian and the geographic constraints of this particular property and its location are what is causing us to request that variance. So in essence, our hardship is that the geography of the river, the geography of Coley Davis is requiring this bridge crossing to be at a 28-degree skew instead of a 15-degree skew.
Can I make one more comment on the CSX? The Planning Commission meeting minutes that we've supplied to you goes into great detail and discussion about CSX. So it is in writing, it is in print, and it was relied upon by the Planning Commission.
Go ahead, Jim.
Well, okay, aside from hardship, part of what we also look at is danger to life and property due to flooding or erosion damage, safety of access to the property in times of flood and ordinary emergency vehicles, but also the impacts to the floodplain and buffers. And so I would, yes, having additional access does provide a safety benefit during times of flooding. I understand that. And I do understand that the geography and the requirements that have been placed on the development could potentially be considered a hardship. That's for us to continue to discuss and roll on. But I would also like to circle back to the impacts to the floodplain and buffer and mitigation as a piece of the conversation. And I'd also like you to speak to the Lomer that you've submitted and got comments on, the status of that and TDEC permitting, because we typically require seeing, that documentation and those permits being approved also.
Right.
As
So
part of-
we already have an ARAP issued for this, so that's been approved. We did receive comments from the Lomer. We have not responded to those comments because we redesigned the bridge and changed the model to accommodate the comments that were received here. So until this is resolved, we're not going to resubmit a new model to them. But the design change only decreased the impact, so there's no reason to believe that it would be problematic. We will have to go through the whole Lomer process. Staff requires that. You guys require that. Does that answer all your questions?
Can you speak to the comments on the submitted Clomer, even though it's been redesigned?
Yes, I mean, we did receive comments and we will address all those comments.
But what was the nature of those comments?
I don't have all of them in front of me. I can tell you that one of them was to consider adding more cross-sections within the model, just to give yourself more there. There was no comments on the structure itself. There was no comments on end values. There was no comments on anything else. It was just with regard to proximity of cross-sections.
They want a more refined model?
They want more cross-sections
More
within the model.
cross-sections, so the model's going with increased validity.
I mean, we can discuss, everything is within standards that I submitted. So there is always a comment within your Lomer process that asks you to consider other things, kind of like what we're here for, right?
Okay, just wanted clarification on that.
The one thing I haven't heard talk about, what we talked about last time, was the raising of Cooley Davis Road. Are we still raising the road? And we haven't really talked much about that impact. And
So we are still raising the road. We redesigned it so that we didn't have to have a variance to raise it, so that we're within the existing footprint. So we did work with NDOT to change the cross-section through a portion of it to, reduce the impacts. Previously, we had shifted Coley Davis to get it out of Zone 1, but that put it into Zone 2. Now we're just leaving it where it is, so it doesn't require a variance, and we're elevating it in asphalt lifts.
Staff, have any comment about that in your review? We're raising Cooley Davis Road, is it 4 feet, I think, or it was something significant?
It's part of our natural review.
Yeah.
We'll look at the cutting and filling. And I think they submitted information to us concerning the sections that they're going to be switching the roadway from one side to the other side to reduce the impacts.
Great. So I'm asking these questions as we work towards a vote on this motion because the applicant has gone back with the feedback from our commission from last meeting, and I want to make sure that's heard by the public as well, because we're listening to you and your concerns and want to be able to objectively satisfy them with data. So it'd be helpful just before we do cast a vote on this, if you could help me with those from last time to this time, just the highlights of that, because Cooley Davis was an important one as part of our last discussion and raising it and realigning it, that I think will be important for the commission to hear before we vote.
So overall, some of the changes that we had were we dropped the previous variance request for the educational signage, and we moved educational signage into our mitigation. So we're utilizing the existing signage as proposed and adding the educational signage as well. So we didn't need that variance. We, again, redesigned Coley Davis. I believe it's maybe, Rebecca, is it towards 112? Can you push us to 112? Thank you. We do have a cross-section that I can.
Yeah, I just want to make sure, it's nice to have, here's where we were before we came before you as a preliminary, and here's where we are today with hearing the concerns and making sure that we've got everything addressed.
We did also, as we mentioned, redesign the bridge in order to minimize impact. As the Commissioner Abbott mentioned, to great extent, with changing from concrete girders to steel girders, skewing the abutments, moving them further out, increasing the total length of the bridge, also raising that low chord up, and going from a 5-span to a 3-span.
And so the bridge piers, and I'll let you continue on, but they're, oh, I see them in that image now. Okay, yeah.
Mr. Chairman, while she's trying to pull that up, I just want to mention that the Coley Davis roadway improvement project is intricate with the bridge construction project. So while it all is one roadway improvement project, only the bridge crossing is what's necessitating, the variance because of that skew and the distance.
Right.
But unless the bridge receives your approval, Coley Davis Road does not get raised. Metro hasn't done it since 2010. They're not going to do it again. My client's raising it, and that's to the public benefit of everyone that lives down Coley Davis Road. So when we think about public benefits of what we're asking here to allow to be done and constructed, again, all the relevant factors, and that's an important relevant factor.
Thank you.
And while we're talking about location too, just to confirm, since this is about location and skew and variance, Metro Parks has reviewed the location in terms of its impact to its fields and whatnot, and is comfortable with that location and with the current designed location. That's okay. I was just asking if Metro Parks has reviewed and its current location that's being proposed at the current skew to its impact to the current Metro Parks parcel and the associated fields.
We have reviewed it. It will impact slightly the trail that's on the site. We'll have to adjust that a little bit, but that's the only impact. I will say that without the Metro Park land that we received in a donation, the 51 acres is landlocked. We do not have access to that property without crossing the property that the Ariza group owns. And so there is that public benefit to having that vehicular bridge, which we would have to build otherwise to be able to get to that property.
Also, just a reminder, there was a first and a second. I believe the first was to approve, a second to approve, and there's discussion, so I just didn't want us to lose it.
That's right.
You're doing the right thing. It's still sort of sitting out there.
That's right. I just wanted to make sure that we had all the before and after confirmed into that as information as we make the vote. So, all right, is there any other, oh, sorry, go ahead. Did you have something that you wanted to show us since you found your page?
I was just going to show you, this is the newly designed bridge.
Whereas before, give me the primary changes from before. I know you moved the abutments out 100 feet from the bank.
Right, and so the steel girders, so instead of concrete girders that are supporting the deck, it's steel girders, which allowed us to shorten how tall those were. So raise the low chord, so the 100-year passes underneath that. And then the skew angle of the piers, the supports underneath.
And what is the mitigation versus area impacted?
The total was in the, yeah.
1.62 acres, and proposed mitigation is 7.06. Which includes the trail as well. So the total disturbance of both the, thank you, yes. 2.68, and the mitigation is 7.06.
So the 7.06
is the mitigation.
But it's for that and the greenway, as you discussed earlier.
That's correct. It is for both the bridge and the greenway. The total disturbance, the total impacts for both the greenway and the bridge is the 2.68, and the total mitigation is the 7.06. Of that, the disturbance associated with the bridge is 1.62 acres, which is included in that 2.68.
Okay, thank you.
Okay, we have a motion. We've had a second. This is, again, related to the items that are being requested to us in the variance related to the skew and then the distance from the adjacent bridge. Is there any other discussion? Is your mic okay? I'll cast a vote. All in favor?
Can we repeat the motion, just so everyone's clear?
It was, go ahead, Mr. Lewis. I'll let you.
Oh,
I'm sorry.
A motion to approve the variance for the skew. And the additional, I mean, yeah. He was, yes, yeah.
Any other discussion? Okay, cast a vote. All in favor, say aye.
Aye.
Aye. Any opposed? Seeing none. Any abstained? Seeing none. Motion carries. Thank you. All right. Yes, you need a break? Okay, I think we're about done. Is there anything else on the?
We just need to look through some dates, I think, for next year.
We'll take a 5-minute break and resume. Thank you. I think this will be our last little business. Logan?
I just want to walk through the dates for next year that I had. All of them are the first Thursday except for January and July because they fell pretty close to a holiday. So if anybody has any concerns about any of those, just let me know. All right.
Yeah, I think
8:30. I haven't confirmed the rooms yet. I mean, I'm hoping we can be in this room pretty regularly, but we will confirm that and we'll send everything out.
Okay. Any issues? All right. Anything else to discuss?
Nope.
Motion to adjourn? So moved. Okay. All right. Good job, everybody. Thank you all. Bye.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.